proceedings under 179 and 10th schedule are concerned, if there is a notice under 179, then the 10th schedule exercise of jurisdiction is brought to a standstill till 179 is decided. Is all that Nabam Rebia is about.
Eventually, Mr. Kaul, on facts, your case is very clear. Your case is, look, once the trust vote was called by the governor, you moved the Supreme Court. You means they moved the Supreme Court, seeking a stay on the trust vote. 29th, our court says no, there will be no stay on the floor test in the House. Rightly so, because there can't be a stay on floor test. That's the ultimate litmus test, as we have always said. Thereafter, the only course of action for them was that, well, face the House and then decide how much of the vote is ultimately influenced by the presence of the persons who were sought to be disqualified. They obviated that by resigning. They never faced the House.
I could not have put it better, and why I'm emphasizing.
That is really the point which they will have to deal
with. Why I'm emphasizing on this is
because ultimately you don't face the House at all. That is something we'll hear.
Why I'm emphasizing, and my lords, I'll also deal with Nabam Rebia and show some of those judgments and the provisions and Constituent Assembly debates. I'll just come to it. The reason I'm emphasizing on this is, my lords, because this whole impression is given that it is because of this order that defection, toppling of governments, things against constitutional morality happened. That's completely wrong.
The process had commenced probably on the 21st itself.
Right.
It's obvious from the meetings which were being held by both the factions.
Right. And my lords, it is no one's case that when the resolutions were adopted on 21st, 22nd, undoubtedly has a majority of MLAs within the party. They now try to get out of it by saying, no, let's look at the larger political party, not the legislature party, which in any case, the Lords has said is for the EC to decide. And we'll get into those issues at a much later date because those are complex issues. Which taluka, which district member, how many members, that's a separate issue.
Mr. Skolby, I think we've got the hang of the facts now. The facts have been...
So, my lords, let me now go on to...
Go directly to Nabam.
Nabam, and my lords, I'll cite Nabam and a few other judgments and make good my submission, my lords. Yes.
We'd also like to hear you on whether a reference to Nabam is a live matter in this case. There is something which we would like to, because that's an area which we are open. You can argue it at two levels. First, you are entitled to argue that don't refer Nabam in this case. And two, that Nabam, in any case, according to you, lays down the correct position in law.
So don't refer.
Sorry. So don't refer.
So don't refer, and it's no longer a live matter.
The second point
is what your lordships are saying.
Yeah.
That is correct.
Once you say that it is correct, there's no question of...
Yes. Very well.
I think your point that Nabam, the reference doesn't arise, you have already dealt with in your statement of facts, because that's why you've highlighted the fact.
Not only that, my lords, I want to show to your lordships, because it fell from my lord, the Chief Justice, in the proceedings. It's free flow. I want to dispel that impression and show what was Nabam all about. Under what circumstances Nabam was. What were the Constituent Assembly debates? No. At length arguments were addressed on that. And that is why That is to be decided in a disqualification. As Nabam is concerned, now I'll just come to the relevant paragraphs and I'll read a few paragraphs from the majority decision and also Justice Mishra's separate opinion on the matter. Now, the point was this. The word freezing did not mean that whatever is the then strength, irrespective of disqualification under 102, 1 or 191.1, or a member is dead, is frozen. It has to be read contextually. Justice Mishra deals with it and says that, look, the approach we are adopting, that the powers exercised by the Speaker under the 10th should, in the meantime, he should hold back till 179 is decided, is in consonance with the provisions under the Constitution which exist, which are, and he relies on Article 181 and Article 189 to say, let's see a scenario in 181 where he can vote on a resolution against his removal. But if it's a tiebreaker, he cannot vote because he.
Justice Mishra puts it really on this ground that when the Speaker exercises the power in qualification under the 10th schedule, I think he has to act impartially. It's in the nature of a judicial function.
Absolutely.
Therefore, anything which is liable to affect your credibility in the discharge of a judicial function must therefore govern when he.
I bow down.
When his own authority to act as a speaker is called into.
I bow down.
The logic.
But he adds a very important argument also to it by saying that the provisions of the Constitution as they stand indicate and support exactly what we are saying, and that was in the mind of the framers, because 181 entitles a speaker to vote in a resolution against him, but not in a tiebreaker. Because in a tiebreaker, then he would be a judge in his own cause. But under 189, he cannot vote except in a tiebreaker. So Justice Mishra draws that distinction and says even the provisions as they exist before the 10th schedule was introduced did indicate that the speaker in these matters must reflect a position of complete impartiality and avoid any form of conflict of interest. I'll read those paras to you, Lord.
Just those 2 or 3 paras. Let's.
Yes, and my Lord,
why don't we look at the provisions
and just one
go to those 3 or 4 paras that will really cut short everything.
Yes, and then my Lord,
it's the heart of the matter.
Yes, and then one more thing, my Lord, before I come to Nabam Rebia, just one more thing. Nabam Rebia also discusses the fact, and Justice Mishra discusses it, that all the provisions that you're now referring to were framed and adopted at a time when there was no 10th schedule.
Yes.
If 10th schedule was in place, and I'll rely on some judgments to say that no provision of the Constitution ever should be fossilized if there are changing circumstances, emerging problems. Your lordships will take an evolutionary interpretation to deal with that problem. The problems that are being placed before your lordships to say Nabam Rebia are wrong are completely procedural. To say on the last day of the session, a notice is given, then there is nothing for 6 months, or a notice is given but no resolution is moved. These are hypothetical problems that you're thinking of that can't be the basis of Nabam Rebia being referred, my lords. I'll show rules which do provide for an expediency, which do provide for an expeditious disposal. Those checks and balances your lordships can always consider if there is a scope after a notice of misuse. But there is a difference between saying that after a notice is issued, there could be a scope for misuse by a resolution not being moved, or a notice being issued on the last day, and to say that the law laid down by Nabam Rebia is not correct. Those procedural misuse, if at all, today these are just imaginary misuses which may occur, could occur, can't be the basis, according to me, for a 5 judges decision being referred to a larger bench. If that were to be so, your lordships in an appropriate case can deal with it. That you can't hang on to it and not decide the matter indefinitely, especially when the rules itself provide for 7 days notice, decision as early as possible. Those indications are there in the matter. But what you're seeking to say is that right in the meantime, there can be no hiatus. There was great emphasis laid on the word there was no hiatus in a constitutional functionary. Now, that constitutional functionary who assumes jurisdiction under 10th schedule, two dangers lie. One, and the argument sought to be made before your lordships were that 179 and 10th schedule are separate, and thus one cannot be interfered with the other. There are two dangers with that argument. One, the very continuation of the speaker under the 10th schedule and assuming jurisdiction as a tribunal is dependence on his legitimacy to continue, which is being decided in a 179. Secondly, the danger, the moment a notice is issued to the speaker, and your lordships have time again from Kyoto to Nabam Rebia said that these are realities of the time, speakers are also political appointments. These are words of the Supreme Court used, and we can't ignore the fact that there may be a scope for misuse in these matters. That speaker who has to misuse or work towards an unconstitutional end will not wait till the date a resolution is moved or a motion is moved in terms of 179 read with Rule 11. He'll start acting as of yesterday on the date the notice is issued. And if in the process he disqualifies all the MLAs whom he feels will be inconvenient to his interests, the entire pool changes. And that is where Dr. Ambedkar, when he referred to the then 10 members of the House, said that you can't restrict it to the majority of present and voting. It should be majority of the then members. What was the reason behind it? The reason behind it was that the strength of the House should be reflected. Now, naturally, the argument in 191 can't be that by using the word freeze and the then members and strength of the House, Nabam Rebia has ignored that so many people may die, may be disqualified for other reasons. That's not what Nabam Rebia says. It only says that 191 subclause 2, 191 and 102, my lords, consciously make a difference between disqualification, as I had respectfully submitted, on grounds mentioned with the governor or the president taking the decision in consultation with EC, and 2, referring to the Lok Sabha, to the 10th schedule and the speaker of the Lok Sabha.
Mr. Kaul, why don't we do this? Why don't we look at the we'll allow you to sort of create a theory based on the bare text of the provision.
Yes, yes.
You go to Nabam and
yes, yes,
let's
yes,
look at the provisions first.
So, my lords, let's
we look at it independent of Nabam, and then see whether Nabam is correct or otherwise.
Yes, yes.
Because let us first look at it as
so, my lords, what I'll attempt to do is I will just show to your lordships 191, 192.
Yes.
Paramateria is 102, 103 for the parliament. Then I'll show 181, 189. And I'll straight away thereafter come to the paragraphs of Nabam Rebia.
That will be logical then.
On this aspect, my lords, before I...
You can read it holistically, taking within its sweep even 10 schedules.
Yes, yes, my lords. So please have... My lords, I'll start with 191 since we are dealing with an assembly instead of 102, 103. Please have 191.
Because we read it.
A person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of a state, A, if he holds any office of profit under the Government of India or the Government of any state specified in the first schedule, other than an office declared by the legislature of the state by law not to disqualify its holder, B, if he is of unsound mind and stands so declared by a competent court, C, if he is an undischarged insolvent, D, if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance or adherence to a foreign state. E, if he is so disqualified under any law made by Parliament. Explanation: for the purposes of this clause, a person shall not be deemed to hold the office of profit under the Government of India or the Government of any state specified in the first schedule by reason only that he is a minister, either of union or of such state. 2, a person shall be disqualified for being a member of the Legislative Assembly or Council if he is so disqualified under the 10th schedule. So 10th schedule, my lords, firstly is a separate provision altogether. Then 192. If any question arises as to whether a member of a house of the legislature of a state has to become subject to any of the disqualifications mentioned in clause 1 of Article 191, the question shall be referred to the decision of the governor and his decision shall be final. Before giving any decision on any such question, the governor shall obtain the opinion of the Election Commission and shall act according to such opinions.
Yes.
Now, my lords, please have. This, my lords, was for the proposition that when the word freeze, the then members are considered, and the argument sought to be made is Nabam has got it completely wrong, because a person could have died, a person could have been disqualified for other reasons, etc. Everything is frozen on that date. That's not the context. The context of the word freeze is that anyone who can be disqualified by the speaker under the 10th schedule will not be disqualified, and the then members of the House or the composition of the pool of the House at that stage will be dehorse the exercise of power under the 10th schedule.
Now, which is the next provision you want us to see?
Yes, my lords. The next provision is 181. This is the provision. This is 2. My lords has 181. Article 181.
Yes.
The speaker or the deputy speaker not to preside while a resolution for his removal from the office is under consideration. At any sitting of the Legislative Assembly, while any resolution for the removal of the speaker from his office is under consideration, the speaker, or while any resolution for the removal of the deputy speaker from his office is under consideration, the deputy speaker shall not, though he is present, preside, and the provisions of clause 2 of Article 179 shall apply in relation to every such sitting.
Start with
Let's see 179.
Yes, ma'am. I'll start with 170. I'm sorry, my lord, I should have started with 170. Vacation and resignation of and removal from the office of the speaker and deputy speaker. A member holding office as speaker or deputy speaker of an assembly, A, shall vacate his office if he ceases to be a member of the assembly. B, may at any time by writing under his hand address, if such member is the speaker, to the deputy speaker, and if such member is the deputy speaker to the speaker, resign his office. And C, may be removed from his office by a resolution of the assembly passed by a majority of all the then members of the assembly, provided that no resolution for the purposes of clause C shall be moved unless at least 14 days notice has been given of the intention to move the resolution. Provided further, whenever the assembly is dissolved, the speaker shall not vacate his office until immediately before the first meeting of the assembly after the dissolution. And now, my lords, may I read 181 again, Your Lordships?
Yes.
The speaker or the deputy speaker not to preside while a resolution for his removal from office is under consideration at any sitting of the Legislative Assembly, while any resolution for the removal of the speaker from his office is under consideration, the speaker, or while any resolution for the removal of the deputy speaker from his office is under consideration, the deputy speaker shall not, though he is present, preside, and provisions of clause 2 of Article 180 shall apply in relation to every such sitting as they apply in relation to a sitting from which the speaker, or as the case may be, deputy speaker is absent. The speaker shall have the right to speak in and otherwise take part in the proceeding of the Legislative Assembly, while any resolution for his removal from the House is under consideration in the Assembly, and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or any other matter during such proceeding, but not in the case of an equality of votes. Now read this, my lords, with 189. Article 189, my lords. My lords, have 189?
Yes.
My lord, the Chief Justice.
Yes.
Voting in houses, power of houses to act notwithstanding vacancies and quorum, save as otherwise provided in this constitution, all questions at any sitting of a house of the legislature of a state shall be determined by a majority of the votes of the members present in voting, other than the speaker or chairman or person acting as such. The speaker or chairman or person acting as such shall not vote in the first instance, but shall have and exercise a casting vote in the case of an equality of votes. So, my lord, Justice Mishra relies on it to say that these provisions also are an indicator of the constitutional trust, avoidance of conflict of interest, and any decision which directly impacts him. 181, where there is a tie, he cannot vote. In other cases, he cannot vote, but if there's a tie, he can vote. And he said these are all indications, and it's the same principle that we are adopting. when under the 10th schedule, where he is to decide on the people who may tomorrow vote against him under 179, and if he takes a decision to consciously disqualify them between the date of the notice and the resolution under 179, he would have altered the pool.
181 is the flips the.
Yes, yes.
So 181 says you can speak and vote, but not in the case of an equality. 189 says that the speaker can vote only when
Yes,
there is
of a tie.
of a tie.
Yes.
So the normal rule is that the speaker can exercise the right to vote when there is a tie, but where the vote is on whether he or she should be removed, then he can't
Right.
exercise it.
And that is what Justice Mishra relies on to say as one of the grounds that he derives his strength and support from. Apart from the larger picture of constitutional trust and conflict of interest, those are the provisions that he relies on to come to the conclusion that he does in the matter. So that impartiality of the highest standards is maintained. And conflict of interest in any form, even the remotest, in matters, I'm giving this is actually a problem. And that is exactly what unfolded in this matter. That the moment a notice is given for removal, you start diluting or altering the composition of a pool of people who will vote for you or against you under Article 179 of the Constitution. So if you've already succeeded in what you were to do, will be a fait accompli.
If you look at it purely in a literal, we've never interpreted the Constitution just literally. It's an organic document. But if you interpret Article 181 in a very literal sense, it places only one disability on a speaker. That disability on a speaker is that once a motion for the removal of the speaker is under consideration, the speaker shall not preside on the motion where his removal is under consideration. But while he cannot preside, he can participate and vote, but not exact. The mere fact, we'll now read whether that is affected by the 10th schedule, how the 10th schedule affects it. Because 181 was brought in before the 10th schedule came in.
Right.
191 was amended to bring in 191 too because of the 10th schedule.
Right.
181 seems to suggest that save and except for this disability on a speaker who is facing a motion for removal, namely that you shall not preside you are entitled to speak and vote, but you will not cast a casting vote. Save and except for this disability which is cast under 181, the Constitution places no other disability on the speaker.
But that disability, my lords, is where a direct conflict of interest as far as his own removal is concerned. That section, that article only deals with his removal.
Therefore, that now we are imposing, as Justice Mishra also imposed an implied limitation on the power of the speaker. Now, he develops that implied limitation on the basis of the 10th schedule. Because there's nothing in Article 181. 181,
Yes, my lords, absolutely.
Justice Kehar reads that in, which Justice Mishra also in passing refers to by the use of the expression the then members of the assembly. Right. And that is probably the weakest link in the argument. Presiding
restrictions are.
Mr. Paul, if we can read a principle, into 180, 189.2, right? And into 189, 181, 181.1. If we can read, what is the constitutional principle? The
Yes, sir.
constitutional principle is a principle. There is a principle of constitutional bias, namely
Incorporation of a
that when
principle
your
bias.
right, when a motion for your removal is under consideration, you shall not preside as a speaker, right? Because if you preside, then you will channelize the debate, you will channelize the conversation, the dialogue in parliament, in the state legislative assembly. So it incorporates the principle, the rule against bias.
Rule against bias.
So 181 is a constitutional incorporation of the rule against bias.
One.
But it also incorporates the principles of natural justice by saying that, look, you can certainly speak, but it dilutes a little bit of the principle of natural justice by saying you can also vote on a motion for your own removal. Normally, you can't vote on a motion for your own removal. It allows him to vote on a motion for his own removal, subject to the caveat that the casting vote which is given to you in your capacity as a speaker, you will not vote. You will not wield on that occasion.
Right. So, Manoj,
So it's a very delicate,
yes, but
it's a very beautifully formulated principle.
but delicately balanced.
No, it
keeping
takes
in mind-
care of all aspects of the matter.
Right.
It takes care of the bias part of it, which is an institutional principle. At the same time, it takes care of the individual right of the speaker also, giving him an opportunity to speak.
Now, what Nabam does is, by sourcing these, though it doesn't say so in Justice Mishra hints at it, by sourcing these principles in 181.2, what Nabam does it extends it a little bit by saying that if the vote on your removal as a speaker is liable to be affected by the exercise of your power under the 10th schedule, then you can certainly affect affect the outcome of a motion for your own removal by exercising or not exercising your powers under the 10th schedule. So therefore, don't exercise your powers under the 10th schedule so long as the vote for your own removal is not is really fluid.
But the real question is that when does that obligation commence upon the speaker? That is on the basis of the notice or prior in point of time. At what time it comes? That becomes very crucial. Even if we take this interpretation.
Mr. Paul, you have to make submission on under consideration.
Under consideration.
At what stage it can be said to be under consideration? Huh? Taking up the that can be said to be taking under consideration.
Correct.
Now, Manoj, may I address it?
See, the 170, the proviso to 179 says 14 days notice has to be given.
That's right.
Of the intention to move the resolution. Does the prohibition attach the moment an intention to move a resolution is given within the meaning of the proviso to 179? Or does the prohibition attach when the motion is under consideration within the meaning of 181.2? And then, how do you, as Brother Shah said, what is under consideration? Does under consideration begin even when the notice for moving the resolution is given under 171, under the proviso to 179? Or does it become under consideration only when the House takes up motion for debate? You can reflect on it at lunch. We'll come back at
Malad, I just want to say, Malad, there are a lot of arguments have been made on facts, Malad, which I not.
But now this is, we are not.
I hope, Malad, that because all the facts that my learned friend mentioned, Alve mentioned.
Rebutting on what arguments
No,
they
no,
opened with on facts.
I never made any argument. Lordship
I
told
think you
me.
did a sizable argument.
Facts we are good to where, because Malad, a lot of these facts have been misrepresented and against the record. So I don't want to go into that, Malad. I mean, we are talking of only on the issue.
I'm not getting into it. I thought substantial arguments on
Yes.
facts. Grateful.
Mic check. 1, 2, 3.
First is 101.
Mic check. 1, 2, 3.
First is
Mic check.
70.
Mic check.
75.
1, 2, 3.
75. Same. Once you disqualify,
Mic check.
75.
Yes, the same thing as 164.
So this is 91st amendment.
That's right.
101 and 102.
This green, this is unmuted. Check my check. Looks like we have said.
भैया हाँ तेज धक्का I told my yes.
Friends, before I come to Nawab, before lunch, when your lodges rose, what your lodges had observed was that under Article 181, a fine and delicate constitutional balance is maintained by the framers of the Constitution. So, on one hand, you will not preside, you will not vote in a tie. You could vote on any matter connected with the removal, but not in a tie, and you will not preside so that you don't channelize, as my Lord the Chief Justice said, a debate in a particular direction. That's the fine balance in this case. But please keep in mind that this balance under Article 181 is one in a scenario where the entire House is involved. The Speaker is not all in all. The entire House is involved. Even there, quite contrary to 189, they say in a tie, you will not vote. Under the 10th schedule, when the Speaker acts as an adjudicatory board, deals with an issue as a tribunal, he's the all in all in that situation. So, how will a fine constitutional balance dealing with a scenario under 10 be maintained? And that is my respectful submission that if, as the words as used by my lords, that if constitutional violence and bias are to be avoided, as it is avoided in under 181, is to be avoided under the 10th schedule. The date has to be the date of the notice. And that is another thing directly dealt by Justice Mishra in his judgment, saying that those days between the date the notice is issued and the 14 days to move a resolution, the entire composition could be changed of anyone who is inconvenient. And what happens thereafter? Whereas in the case of an MLA who is then later disqualified, he can come and get it rectified as far as judicial review is concerned. But what happens that he misses that opportunity to vote? There is no judicial review of a removal. What is also important is there is no vested right to continue as a speaker. If you are removed as a speaker and you win the confidence of the House again in a scenario, you can be re-elected as a speaker. You don't lose your membership of the House. Whereas as a member of the House, if you are disqualified unfairly by the speaker who wants to alter the pool so that he can win his election under, he can defeat a resolution for his removal under 179, the bedrock of democracy is shaken, because not only do you lose your right to vote in parliament, there is a whole constituency which goes unrepresented. So we are talking about a much greater harm, even if we are balancing the two. You're dealing with a person, a constituency going unrepresented, an elected representative losing his right to vote, which shakes the very bedrock. A speaker can always get re-elected if he has and he doesn't lose the membership of the House. So all that I am respectfully submitting, my lords, is that the potential harm of the constituency being left unrepresented and a government which is not enjoying the support of the members being established, because if you've removed half the members who are inconvenient to you, something far more dangerous and damaging to democracy can happen. And that is why in para 191, Nabam Rebia says that if he establishes his confidence, wins the vote of confidence, then he goes on to decide. And as far as the members are concerned, if they are unfairly disqualified thereafter, the court can set us aside. But you can't avoid your resolution for being removed by first disqualifying the members. It is in that context. So 181, when it maintains a fine, delicate balance, it is not dealing with the 10th schedule scenario at all. Now in 10th schedule, my lords, I take it. Suppose as it's being argued, it should be at the date of motion or it should be date of resolution. That's being argued that if at all someone has to hold their hand, it should be at that stage. Now, my lords, these are all matters of procedure. 14 days notice, resolution, motion under the rules, whatever you may call it. But the speaker who intends to change the composition of the then members of the House will not wait till that stage.
What is the point of time at which the disability on the speaker?
My respectful submission is, and that is what I am now coming to Nabam Rebia, is on the date of the notice under 179 subclause C proviso. When that notice is issued under 179 subclause C proviso, is when the disability comes in. Because as Justice Mishra deals with it, that the moment you express your intention to remove a speaker, he can start acting. He doesn't have to wait till the resolution is moved. Till the motion is moved.
But that will have very serious ramifications for the reason that a person who moves the motion, you require only one person to move the motion.
Right.
There's no threshold required. Second, the person who moves the motion, who moves the notice, who issues the notice may not move the motion at all.
So
this would be capable of grave misuse. That is to prevent the speaker from exercising any power. You have to only say any power to decide the disqualification. You have to only get one person to issue a notice to the speaker that I'm asking for your removal.
Well, just see.
It's like a beat.
Does it lapse?
We will get a better picture if we see the constitutional provision along.
See the rules now.
Rules show us in the context of rules.
States and on the strength of one notice.
So I was just answering that. I had addressed your lordships today in the morning on that. These are what are examples being given that someone moves a notice, does not move thereafter. Or someone gives a notice on the last day of the session, when the session ends and 6 months later. My lords, these are situations of procedure or a possible misuse of procedure which can be corrected by interpretation. But to say that because of this, Nabam Rebia is bad law, is what is wrong. These are issues after all, and I show rules. There are rules within the...
Nabam, according to Nabam, the disability gets on the speaker.
Yes, but my lords, what I am saying is,
the notice is...
I'll show I'll show that if the danger is a misuse of a procedural irregularity or a procedure being misused of notice to the period of resolution being moved, even the rules say as soon as possible, within 7, I'll show those rules as they come forward.
Let's see the rules now.
Yes. Manoj, can I do one thing? Can I just go through Nabam so that we at least
All right.
have that, and then I'll move on to the rules. Manoj.
All right.
We'll get a better understanding. We see the rule first.
Because,
Yeah.
we have seen the constitution. Now let's see the rules.
We'll independently
So
go
that
through
then
the
we
rule
can
and then
independently look at
see
the
judgment.
interpretation and then see Nabam.
Page 40 of
So Nabam is at 973, volume 1.
Yes. Manoj, can I start with that, Manoj, and then come to the rules?
I feel that's better. No, let's go to the rules, I think.
Very, as you know. Can I first take your lordship through Rule 11?
Where are the rules?
that's the first document.
3C, no?
Compilation, yes.
Compilation of rules and judgments, 3C.
PDF page 42.
Page 40.
Page 40. First index, page 40.
Manoj, PDF,
Page 25.
42.
page 25, Rule 11, compilation 3C,
42.
25, volume 3C, volume 3C.
Volume? Which volume?
All the statute compilation is at, it's at PDF 42. What grade?
That's correct. That's the full.
A lady that doesn't have the full rule, so this one I
Okay, you have redone it. Okay, all right.
compile rules and judgment.
He's not in first of
Okay,
the compilation of rules.
3C में 11 है, ठीक? Same thing.
PDF?
What is that? 2025. Rule 11.
Page 3C.
Yes.
You could get imagine here.
25.
Yes, we have.
And that's where the court mark. Chetan?
Motion.
Rule 11.
Manoj, have Rule 11. A motion to remove the speaker from office of which 14 days notice as required under Article 179 of the Constitution has been given shall, as soon as may be after the expiry of the notice period, be read to the Assembly Speaker, who shall then request the member who are in favor of leave being granted to move the motion to rise in their seats, and if not less than 29 members rise accordingly, the speaker shall intimate that leave is granted, and then the motion will be taken on such day, not being more than 7 days from the day on which leave is granted, as he may appoint. If less than 29 members rise, the speaker shall inform the member who may have given the notice that he has not the leave of the assembly to move it. So, my lords, one is that 14 days notice as required, so shall be given as soon as may be. I'm just on the indications within the rules. As soon as may be, and then it says not being more than 7 days, both on an expeditious disposal. Now kindly have 18. My lords have Rule 18.
It says on the receipt of the 14-day notice,
So there are 4.
as soon as may be after the expiry of the notice.
Yes.
So therefore,
14 days has to be, my lords, because that's what the Constitution provides for.
14 days notice must expire. And then the members who have made the request
As soon as may be
should
after the
seek
expiry,
leave
be read to the assembly of the speaker, who shall then request members who are in favor of leave being granted to move the motion to rise in their seats, and if not less than 29 members rise accordingly, the speaker shall intimate the leave is granted and that the motion will be taken on such day, not being more than 7 days from the day on which the leave is granted. Read it in totality, my lords, with Rule 18 and Rule 20. And the scheme adequately of the rules provides that these whole thing that you give a notice and you forget about it, nothing happens after that, then someone sits on it and there's a hiatus and the speaker can do nothing after that. And if at all such a situation were to arise in some case, my lords, it could be dealt with, because that is what your lordships, all these judgments on transformative interpretation, evolutionary interpretation are. Today, the point is not that. The point is, can a speaker, while his removal is pending under 179, alter a pool? That's all that Nabam Rebia decides. Can you alter the pool while you yourself are the only authority which decides on disqualification, and you can use that power as a tribunal to completely influence the decision as far as your removal is concerned? If that whole pool of removal under 179 changes,
Going back to when
181 fine delicate balances where the whole house is involved.
No, but therefore, according to you, the moment even one member gives a notice, the stay on the speaker attached.
All I'm trying to say is that it won't be indefinite, because the rules provide that resolution should be brought and put to vote. So it's not something
Speaker doesn't do that.
Please, my lords. Taken up under 181. Secondly, as I am respectfully submitting, my lords, please see the word, a motion to the speaker as soon as may be has to take it up. To answer what my lord said, if a speaker doesn't take it up, then a speaker is the person who's the interested party. Then Nabam Rebia, in any case which we feel is the correct law.
Because it is against him.
Yes, yes. So this whole imaginary problems to say there has been no legal answer. They've given things which have not arisen, which have not happened. And that is why I have respectfully submitted, my lords, what is the legal constitutional infirmity in what Nabam Rebia has said, which is that a person whose own removal is to be decided cannot in the meantime exercise a power under another provision of the constitution to alter the set of people who will vote against him or vote in his favor, or alter it to his benefit. Now please see, my lords, Rule 18.
There shouldn't be disqualified.
My lords, has Rule 18. Every notice required by the rule shall be given in writing addressed to the secretary and shall be left to the assembly office, which shall be open for this purpose on every day except Sunday or a public holiday, so and so hours. This period of every notice shall be counted from the day on which it is received, provided notices shall be received and the office is closed, shall be treated as having been received. A copy of every motion other than resolution which notice is received shall be sent to each member after it is admitted by the speaker. And then kindly see 20. And please see 20. On the prorogation of a session, all pending notices shall lapse, except those in respect of unstarred questions. No day yet named motions, statutory motions, amendment rules, motions of consideration of which have been adjourned to the next session under Rule 37, bills which have been introduced and amendments to such bills shall be carried over to the list of business for the next session from the stage reached by them in the expiring session. Now, my respectful submission is twofold, that once the notice is received, it has to be put. We've not come across a case where a notice is given and no one has done anything after that. That is not the case here. The case is not here that on the last date a notice has been moved and we are waiting. In appropriate cases, even a special session could be called if removal of the speaker is the issue. But the question today is that can that be the basis of determining when can the speaker or when the speaker should resist and desist from altering the pool? That's the limited question on Navam Rebia. And naturally, as Justice Mishra and Navam Rebia says, the moment you express your intention to remove a speaker, that's when he starts acting. He'll utilize those 14 days before a resolution is to be moved, or a motion, call it what you may. Resolution, motion, whatever, he'll utilize those days. Justice Mishra directly deals with this issue. And I'll come to it, and there's a reason. He says because there was no 10th schedule when these articles came. So the fine, delicate balance in 181 is to be seen in the context of minus 10th schedule.
But equally, you must also postulate that, look, after the 10th schedule, some of the substantive provisions of the Constitution were also amended. So 191(2) came in by the same 50th Amendment, which brought in the 10th schedule.
Right.
But Parliament didn't make any amendment to 181.
Right. But my lords, as I respectfully submit, but if a challenge arises, if a problem arises, that's where your lordships have used your lordships' rules of interpretation and interpreted provisions to say that constitutional interpretation is flexible to ever-changing situations and problems that arise from time to time. Your lordships have time and again said, if Parliament had taken care of every constitutional situation which may arise, then your lordships' judgments to say that in appropriate cases, your lordships may have to adopt evolutionary and transformative tools of interpretation to meet ever-changing situations would not arise, then Parliament would take care of every situation. But your lordships have utilized those tools, and that is why Nabam Rebia utilized those tools to come to the conclusion.
Any other rule now? Any other rule?
These are the principal three
Now
rules.
let's go to Nabam.
Yes, now let's go to, yes.
973.
Yes, give me a minute. Just give me a minute. Para 188.
1145.
1145 PDF page. My lords have.
You showed us rule, sorry for interruption. Rule 11, rule 18, and which are the
20.
20. Yeah.
What fell from my lords, if as rule 18, for instance, says the speaker will admit on a notice being given. Because look at the other scenario. You give a notice and the speaker doesn't admit it. Like he started in this case by saying it's from unknown people. An advocate's notice that's signed by 34 MLAs. And he's saying it's from an unknown source. So it's for his own removal. And he doesn't want to go through with the motion. What happens then? He ultimately has to admit it. May I read one?
Yes.
Yes. The issue canvassed and answered here para 188. The issue canvassed and answered here and above with reference to the 10th schedule does not fully answer the controversy which has arisen propriety of the Speaker in conducting proceedings under 10th schedule, when his own position as Speaker of the Legislative Assembly is under challenge. After all, this was the real basis of the Governor having passed the improved order and message dated 9/12/2015. The challenge to the Speaker's position in the instant case was based on the notice of resolution for his removal dated 19/11/2015. The resolution was moved by 13 MLAs, 11 belonging to the BJP and 2 independent MLAs. Despite the above, unmindful of the challenge raised in his own position, the Speaker went on with the disqualification proceedings initiated by the Chief Whip of the Congress Legislature Party on 7/12/2015 by issuing notice to them on 7/12/2015 itself, seeking their response by 14/12/2015. All the 14 MLAs aforementioned were disqualified by an order passed by the Speaker on 15/12/2015 under the 10th schedule. Was this action of the Speaker justified? The learned counsel for the rival parties pointedly addressed us on this issue. We are also of the view that this issue needs to be determined in view of the direction which will eventually emerge on the basis of consideration recorded here and above. A repeat performance of the earlier process would bring the parties back to the threshold of this court for redressal of the same dispute which is already before us. When the position of a Speaker is under challenge, through a notice of resolution for his removal, it would seem just and appropriate that the Speaker first demonstrates his right to continue as such by winning the support of the majority in the state legislature. The action of the Speaker in continuing with one or more disqualification petitions under the 10th schedule, while a notice of resolution for his own removal from the office of the Speaker is pending, would appear to be unfair. If a Speaker truly and rightfully enjoys support of the majority of the MLAs, there would be no difficulty whatsoever to demonstrate the confidence which the members of the state legislature repose in him. The office of the Speaker, with which the Constitution vests the authority to deal with disqualification petitions against MLAs, must surely be a Speaker who enjoys confidence of the Assembly. After all, disposal of the motion under Article 179C would take no time at all. As soon as the motion is moved on the floor of the House, the decision thereon will emerge forthwith. Why should a Speaker who is confident of his majority fear a floor test? After his position as the Speaker is affirmed, he would assuredly and with conviction deal with the disqualification petitions under the 10th schedule. And why should a Speaker who is not confident of facing a motion for his removal have the right to adjudicate upon the disqualification petitions under the 10th schedule? The manner in which the matter has been examined here and above is on ethical considerations. A constitutional issue, however, must have a constitutional answer. We shall endeavor to deal with the constitutional connotation of the instant issue in the following paragraphs. Just like the other provisions of the Constitution interpreted by us here and above, it would be apposite to ascertain the desired intent of the framers of the Constitution emerging from the Constituent Assembly debates with reference to Article 179, subclause C. The draft Constitution, the present Article 179, was numbered as Article 158. One of the issues debated with reference to draft Article 158C was with reference to the words all the then members of the Assembly used therein. The above words were used to define those who would participate in the motion for the removal of the Speaker. Needless to mention that the said words were retained in the final draft in Article 179C. One of the members of the Constituent Assembly had suggested substitution of the above words by the words the members of the Assembly present and voting under so-and-so. Mr. Mohammed Tahir, sir, I beg to move that in clause C of Article 158, for the words all the then members of the Assembly, the words the members of the Assembly present and voting be substituted. Clause C runs as follows. Clause C may be removed from his office for incapacity or want of confidence by a resolution of the Assembly passed by a majority of all the then members of the Assembly. Sir, so far as I can understand the meaning of the wording, all the then members of the Assembly, it includes all the members of the Assembly. Supposing a House is composed of 300 members, then it will mean all the 300 members of the Assembly, that is 300. Supposing 50 members of the House are not present in the House, then those members will not have the right to give their vote so far as the question is concerned. Therefore, I think that it would be better that this matter should be considered by only those members who are present in the Assembly and who can vote in the matter. In this phrase, all the then members of the Assembly means the members who are present in the Assembly, then I have no objection. If it means all the members of which the House is composed, I think it is not desirable to keep the clause as it stands. With these words, I move my amendment. The Constituent Assembly debates do not appear to have recorded any discussion on the above amendment. The decision on the proposed amendment was, however, minuted as under. Mr. President, the question is that in clause C of Article 158, for words all the members of the Assembly, the words all the then members of the Assembly, the words the members of the Assembly present and voting be substituted. The amendment was negative. It is apparent that the Constituent Assembly chose to retain the words all the then members of the Assembly and declined to substitute them with the words the members of the Assembly present and voting. We are of the view that the acceptance of one set of words and the rejection of the suggested substitution would effectively render a constitutional answer to the issue in hand. Article 179 subclause C provides that a speaker or deputy speaker may be removed from his office by a resolution of the Assembly passed by a majority of all the then members of the Assembly. A notice of resolution for the removal of the Speaker or the Deputy Speaker of the Assembly would therefore have to be passed by a majority of all the then members of the Assembly. The words all the then members include in Article 179 subclause C are a conscious date. If the words all the then members are excluded from the clause C of Article 179, it would affirm the interpretation which the applicants wish us to adopt. The connotation placed by the applicants would legitimize the action of the Speaker in going ahead with the proceedings under the 10th schedule, even though a notice of resolution for his removal from the office of the Speaker was pending. The words all the then members were consciously added to Article 179C and their substitution was not accepted by the Constituent Assembly. We are satisfied that the words passed by a majority of all the then members of the Assembly would prohibit the Speaker from going ahead with the disqualification proceedings under the 10th schedule, as the same would negate the effects of the words all the then members after the disqualification of one or more MLAs from the House. The words all the then members demonstrate an expression of definiteness. Any change in the strength and composition of the Assembly by disqualifying sitting MLAs for the period during which the notice of resolution for the removal of the Speaker or the Deputy Speaker is pending would conflict with the express mandate of Article 179C, requiring all the then members to determine the right of the Speaker to continue. It would also be relevant to notice that the 10th schedule was inserted by the Constitution's 73rd Amendment Act 1992, with effect on 24/4/93. The purpose sought to be achieved through the 10th schedule is clear and unambiguous. The same is unrelated to and distinct from the purpose sought to be achieved through Article 179C. Neither of the above provisions can be seen as conflicting with the other. Both must therefore freely operate within their individual constitutional space. Each of them will have to be interpreted in a manner as would serve the object sought to be achieved without treading into the constitutional expanse of the other. The interpretation would have to be such as would maintain constitutional purpose and harmony. We would now venture to examine the instant issue from the above perspective in the following paragraph. If a speaker survives the vote on a motion for his removal from the office of the Speaker, he would still be able to adjudicate upon the disqualification petitions under the 10th schedule. The process of judicial review cannot alter the above position. But if a disqualification petition is accepted by the Speaker, the disqualified MLAs will have no right to participate in the motion moved by the Speaker under Article 179C. A disqualified MLA, as we all know, can assail the order of his disqualification by way of judicial review. If he succeeds and his disqualification from the House is set aside, such a disqualified MLA would be deprived of an opportunity to participate in the motion against the Speaker under Article 179C. In this situation, the process of judicial review can also alter the position if a disqualification order passed by the Speaker is set aside by a court of competent jurisdiction. In the event of an MLA having been disqualified by the Speaker, the notice of resolution for the removal of the Speaker would surely be dealt with and will be disposed of during the period when the MLA concerned stood disqualified. Alternatively, if an MLA has not been disqualified when the motion for the removal of the Speaker is taken up, he would have the right to vote on the motion pertaining to removal of the Speaker, whereafter the petition for his own disqualification would certainly be considered and decided by the Speaker. It is apparent that the difficulty arises only if the disqualification petition is taken up first and the motion for the removal of the Speaker is taken up thereafter. The possibility of a disqualification petition being decided on political considerations rather than on merits cannot be ignored. In fact, that is a real possibility. Therefore, while it will not be adversely affect the Speaker if he faces the motion of his own removal from the office of the Speaker, before dealing with the disqualification petitions, it could seriously prejudice MLAs facing disqualification if petitions for their disqualifications are taken up and dealt with first. The adoption of the former course would also result in meaningfully giving effect to the words all the then members used in Article 179C as discussed in foregoing paragraph. This interpretation would also purposefully give effect to the rejection of the amendment suggested during the Constituent Assembly debates that the motion for the removal of the Speaker should be the majority of the members of the present and voting. This interpretation would also result in disregarding the retention of the words all the then members of the Assembly in Article 179C. If the Speaker faces the motion of his own removal first, both constitutional provisions would have their independent operational space preserved. None of the constitutional provisions concerned would interfere with the free functionality of the other, nor would one usurp the scheme postulated for the other. We therefore are of the view that the constitutional purpose and constitutional harmony would be maintained and preserved if a speaker refrains from adjudication of a petition for disqualification under the 10th schedule, while his own position as the speaker is under challenge. This would also allow the two provisions of Article 179C and the 10th schedule to operate in their individual constitutional space without encroaching on the other. Now, finally, have my lords, paragraph 233. PDF page 1162. PDF page 1162, where Justice Mishra's opinion, the relevant paras are. Para 233.
What's the PDF page?
PDF page 1162. 1162. 1166. Thanks. 233. 1166. 1166, my lords, I'm so sorry. 1166. May I? There can be myriad situations in a democracy. The Constitution as an organic instrument has to be interpreted to meet all exigency. It has to have flexibility. Assuming the requisite members express their intention to move the resolution for removal of the speaker from the office, and immediately the speaker on a complaint initiates action under the 10th schedule. And as the resolution against the speaker cannot be moved unless 14 days notice period expires, the members can be disqualified within the said period and the speaker would gain an advantage. Thus, it can result in a situation of constitutional conflict, that is the conflict between the status of the speaker conferred by the Constitution and the position he has been given after the constitutional amendment. The final arbiters have trusted him regard being had to his constitutional status. It is the constitutional trust. Therefore, there should be perceptibility of absence of conflict. That apart, it will not be in harmony with 179C or the constitutional norm. It would also cause discord with the language employed in the said article. The founding fathers had deliberately retained the words all the then members by negating proposed amendment. The purpose of not accepting the amendment is to preserve the constitutional control over the situation. In this regard, I may usefully refer to Article 189 of the Constitution. It provides for voting in the House, power of houses to act notwithstanding vacancies and quorum. Clause 1 of 189 stipulates that, save as otherwise provided in the Constitution, all questions at any sitting of a House of the legislature of a state shall be determined by a majority of the votes of the members present in voting, other than Speaker or Chairman or person acting as such. The said clause also provides the Speaker or Chairman or the person acting as such shall not vote in the first instance, but shall have and exercise a casting vote in the case of an equality of votes. The said clause thus clearly states about the majority of the votes of the members present in voting, and secondly, it empowers the Speaker to exercise his power of voting in case of equality of votes. In contradistinction to the same, Article 181 provides that the Speaker or the Deputy Speaker is not to preside while resolution of his removal from the office is under consideration, and he is entitled to vote in the first instance on such resolution, but not in the case of an equality of votes. Article 181(2) is relevant for the present purposes, reads as follows. Well, that I've already read. I'll come to the next paragraph. If you'll just a minute. 235. The purpose of referring the said article is to highlight the nature of participation of the Speaker when the question of his removal arises. It is clearly different. Under the Constitution, he is entitled to take part in the proceedings and speak. Therefore, he is in a position to contest. Appreciating the scheme of the Constitution and especially keeping in view the language employed in first proviso to 179C, it is quite clear that it is the constitutional design that the Speaker should not do any act in furtherance of his interest that the resolution is moved. In this regard, it is essential to understand the character of the 10th schedule. The 10th schedule to the Constitution has conferred the adjudicatory powers on the Speaker. While deliberating on the constitutionality of the said schedule, the majority in Kyoto Honolulu has stated that the Speaker, Chairman, while exercising powers and discharging functions under 10th schedule, act as tribunal, adjudicating rights and obligations under the 10th schedule, and their decision in that capacity are amenable to judicial review. However, having regard to constitutional scheme in the 10th schedule, a judicial review should not cover any stage prior to the making of the decision by the Speaker's chairman. Having regard to the constitutional intendment and the status of the repository of the adjudicatory power, no quae timid action are permissible. The only exception for any interlocutory interference being cases of interlocutory disqualification or suspensions, which may have grave, immediate, and irreversible repercussions and consequences. That para 6(1) of the 10th schedule, to the extent it seeks to impart a finality to the decision of the Speaker, Chairman, is valid, but the concept of statutory finality embodied in para 6(1) does not detract from or abrogate judicial review under 136, 226, and 27 of the Constitution, insofar as infirmities based on violations of constitutional mandates, malafide, non-compliance with the rules of natural justice, and perversity are concerned. That the deeming provisions in para 6(2) of 10th schedule attract an immunity analogous to Article 122(1) and 212(1) of the Constitution, as understood and explained in Keshav Singh's case, to protect the validity of proceedings from mere irregularities of procedure. The deeming provision, having regard to the words "be deemed to be proceedings in Parliament" or proceedings in the legislature of a state, confines the scope of fiction accordingly. That the contention that the investiture of adjudicatory functions in the Speaker, Chairman would by itself vitiate the provisions on the ground of likelihood of political bias is unsound and is rejected. The Speaker, Chairman hold a pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of the House. They are expected to and take far-reaching decisions in functioning of parliamentary democracy. Stature of power to adjudicate questions under the 10th schedule in such constitutional functionaries should not be considered exceptionable. The aforesaid reasoning eloquently speaks of the power, position, and status of office of the Speaker enjoys under the Constitution. It also states that the scope of the fiction court has constricted the power of judicial review and restricted it to the stage, carving out certain extreme exceptions. It is because the Speaker, while exercising the authority and jurisdiction, exercises the power of constitutional adjudication. The concept of constitutional adjudication has constitutional value in a parliamentary democracy, and constitutional values sustain the democracy in a sovereign republic. The Speaker is expected to maintain propriety as an adjudicator. The Speaker, when functions as a tribunal, has the jurisdiction authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible. It should be beyond any reproach. It must reflect the trust reposed in him under the Constitution. Therefore, the power which flows from the introduction of 10th schedule by constitutional amendment is required to be harmoniously construed with Article 179C. Both the provisions of the Constitution are meant to subserve the purposes of substance of democracy, which is a basic feature of the Constitution. The majority in Manoj Nerula versus Union of India were speaking about the democracy as opined. The democracy in India is a product of the rule of law, and it is not only a political philosophy, but also an embodiment of constitutional philosophy. Thus, regard being had to the language employed in Article 179C of the Constitution and the role prescribed to the Speaker under the 10th schedule, it is necessary that the Speaker as a tribunal has to complete detachment and perceive impartiality. When there is an expression of intention to move the resolution to remove him, it is requisite that he should stand the test and then proceed. That is the intendment of 179C, and the said interpretation serves the litmus test of sustained democracy founded on rule of law. And founding fathers had also intended that the constitutional value, trust, and morality unequivocally so suggest. It would be an anathema to the concept of constitutional adjudication if the Speaker is allowed to initiate proceedings under the 10th schedule of the Constitution after intention to remove him from the office is moved. The 14 days period being mandatory, the word all the then members gain more significance. The Constitution has confidence in the Speaker. I would like to call it repose of constitutional confidence. Simultaneously, the command is to have confidence of the majority of the actual or real figure. This understanding is gatherable from the express provisions of the Constitution, and it clearly brings in harmony between constitutional confidence or trust and the constitutional control. Be it stated, the position has to remain the same even after introduction of the 10th schedule to sustain the robust vitality of our growing Constitution, and it embraces the seminal spirit of rule of law that controls all powers, even the prerogative powers. Now just show me the Dr. Ambedkar's. Now, just in continuance, because your lordship have also read the Constituent Assembly debates on the then members, there is another portion that I wanted to show to your lordships, which is page 196 is what PDF page?
It's the compilation of statute grounds. Starts at page 193.
The Constitution in 181, the restraints which operate on the Speaker operate when a motion for his removal is under consideration. All right. Now, what has been done in Nabam Rebia is to read in certain implied restraints based on a harmonious reading of the 10th schedule on the and these provisions of the Constitution. But those restraints, if we have to be logical, those restraints which we bring in by an implied reading of limitations on the power of the Speaker must also commence when a motion for his removal is under consideration. Right? Now, when is a motion for the removal of the Speaker under consideration? Stage 1 is the proviso to 179C, when a motion for the
A notice.
when notice has been given of the intention to move a resolution.
Yes.
179C proviso reflects the intention of a member
Right.
to move a resolution
Right.
for the removal of the Speaker.
Right.
So I'm going to move a resolution. I have an intent here and now to move a resolution for his removal. As soon as that is given and a period of 14 days has expired, then the rule 11 says that on the expiry of 14 days, the Speaker thereafter has to convene the House, and the notice has to be read.
Right.
If the notice is, if it is supported by 29 members, then leave shall be granted.
Right.
Once leave is granted, then not less than
7 days.
7 days have to be given, after which the motion will be taken up for consideration.
Absolutely.
Therefore, the reading of these rules would indicate that the motion for the removal, the intent, the notice which is given of the intent to move the resolution, the motion is under consideration only after the House has granted leave, and upon the grant of leave, the motion is taken up for consideration after a period of 7 days.
Right.
Because 7 days has to be
Right.
Now, can we say that the motion is under consideration at any stage prior to the grant of leave? We need not go as far as to say that the motion is not under consideration until 7 days have elapsed. That 7 days is for him to really have sufficient opportunity.
Correct.
But the grant of leave is a critical facet, because it is upon the grant of leave that the motion then is to be considered by the House.
So just
It cannot be considered until the expiry of 7 days, but after the expiry of 7 days, then the Speaker,
So just
is on notice.
add to
Then
what
it will be considered.
what my lord said, just to add to what my lord said in all humility, that is exactly
Because prior to the grant of leave, if you don't muster up 29 members,
Yes,
that's this.
right. But what Justice
the
Mishra deals
requirement
with,
is absent.
what Justice Mishra deals with in para 23 is that when that notice is given between that period of 14 days, if the composition is altered, nothing stops him from doing it. Anyone who will ostensibly, as per his assessment, vote against him, in those 14 days from the moment intention is expressed till it fructifies in a resolution or a motion is altered, what happens? Manoj, that's exactly the position that Justice Mishra deals with. We can't say that a speaker who wants to work towards unconstitutional ends will only start working towards unconstitutional ends after a resolution or a motion is taken up, and will not work towards them from the date the intention for his removal is expressed under 79C proviso. He will not wait for a motion to be moved 7 days, 14 days, they will follow. That's the procedure under the Constitution and the Assembly rules. That speaker will start working the day the intention is given to alter the pool. And that is what Justice Mishra says, that how do we protect that period of 14 days before? Your lordships are absolutely right the way your lordships summed it up. But for that period from 179C to 181 and Rule 11, how will the composition of the then members, and this does not include 191 and 1021.
If we are
This is given, it is the speaker who is in charge.
Another point really is that to what extent do we have a certain discretion to tighten up Nabam Rebia?
Arabia. That's what you say.
Because we are also constitution bench.
But, my lords, may I just add, that is why I respectfully
Without making a reference, can we then
my lords, this does
Tighten it up.
tighten it up a little bit?
Not require
Tighten it up a little bit. We got the thrust of your argument. Therefore, we may not go as far as to say that Nabam is wrong.
Yes.
But is it not necessary a little bit to just tighten up a little?
Because all
I'm
period,
thinking aloud, my lords. Your lordships thinks it needs to be tweaked and tightened as far as the procedural part is concerned.
Right.
Your lordships may consider that.
That's what
The issue, and that's what I've been in all you.
Mr. Kaul, what we are trying to, we just want your assistance on this. Can we do it in a bench of 5?
My lords, why?
Maninder is saying, no, you can't do it.
No, my lords, there is nothing contrary. Your lordships cannot
then we
do
have to
something
refer it.
contrary.
Maninder Singh, we have to refer to 7 then.
No, Mr. Kaul.
Can we do it?
Mr. Kaul, listen. Justice Kher and Justice Misra specifically, correct, has taken the view, one view, that once the notice is issued for disqualification, correct, he has to stay his hand.
Yes.
Speaker has not to do anything.
Yes.
Now, if we take a somewhat different view, listen, somewhat different view, correct, that, no, not this stage, but granting the leave can be a stage for the purpose of disqualification to her staying the hands, then can we do it or 7?
No, my lords, I'm sorry. I didn't, what I meant was that as far as the moment notice or intention is expressed to remove a speaker under 179C proviso, and as captured by Justice Mishra in para 233 is concerned, the clock stops ticking. I'm only on the limited issue that if these kind of examples are given, that a notice is moved on the large section. I'm only on that. I didn't mean that your lordships can tweak what Nabam Rebia is there. Yes.
We need not go into that at all. We are now on whether, you see, because there are 2 places in Justice Kher's judgment where the learned judge uses the expression, while a notice of resolution for his own removal from the office of the speaker is pending. That's the specific language which the learned judge uses. Para 189. Just see para 189
Yes.
at page 1145. Yes. Let's focus only on those 2 lines.
Yes.
189, where the learned judge deals with as a matter of first principles, the ethicality or the morality, as he says.
Yes.
189, the action of the speaker in continuing with 1 or more disqualification petitions under the 10th schedule, whilst a notice of resolution for his own removal from the office of the speaker is pending, would appear to be unfair. We'll then go to the next part where he says that. I'll just take you through that as well. The next part is para 193 at page 1149.
Yes.
We are therefore of the view that constitutional purpose and constitutional harmony would be maintained and preserved.
Because I'm sorry, Placitum, are you?
Yes, Placitum A at your internal page 1136.
We are therefore, my lord, is that?
Yeah, of the view that constitutional purpose and constitutional harmony would be maintained and preserved if a speaker refrains from adjudication of a petition for disqualification under the 10th schedule while his own position as a speaker is under challenge. And 194. We hereby hold that it would be constitutionally impermissible for a speaker to adjudicate upon the disqualification petitions under 10th schedule, while a notice of resolution for his own removal from the office of speaker is pending. All right, these are the two. So 189 and 194, which we saw. Now, Justice Mishra at page 238, we go to 1166, para 238.
First, if your lordship are again
Just one
reading
second.
233 also.
Sorry.
233 will be in continuation of what your lordships are saying.
Right.
Please see 233 for a minute. Just
Yeah, that's what I'm saying. 233.
Yes.
233.
Yes.
And
Can I read 233 for a minute?
that is a rationale. That's the rationale. We're now looking at what is the bottom line that they hold. You're right. 233 gives us a rationale, which you have taken us through as well, independently of this. Now, if you just see what is it that Justice Mishra ultimately holds, he says in para 238. One second, I just marked it here.
1155.
Yes.
PDF
1155 para 238.
Yes.
PDF
1155 para 238.
That's
when there is an placitum G, when there is an expression of intention to move the resolution to remove him, it is requisite that he should stand the test and then proceed. So both.
How do you feel there are Article 79, it speaks of 14 days notice.
Of the intention to move.
Intention to move. Now, crucial expression is move. Moving from 179, when we come to the rule creates a further period. It creates 4 segments. First, it incorporates 179, that 14 days notice. Then it provides speaker reading it out. And then 111 also provides as soon as maybe after that, the second period comes in. Then it contemplates 29 members standing.
And leave being granted.
And then after they stand 29, then motion comes into play, and then 7 days period comes into play. So these are by virtue of the rule. On interpretation of the Constitution, we may perhaps ignore, I don't really know. We can leave it at, but then the crucial point will be from the date of the motion, intention to move. If we take the move to be the same time when 29 members stand, and then the speaker takes a decision that the motion is moved and 7 days comes into play, then that period will be the crucial period, because all aspects prior to that are incoherent. They may move, they may not move.
But my lords,
all that is incoherent, may not even come into existence.
Really, if it doesn't.
1 minute.
Yes.
They may not come into existence, as so many examples have been given. But this particular act of the speaker identifying 29 members having approved of it, then his mandate, his obligation to complete it within 7 days comes into play. It is that crucial period which should perhaps have scheme. And second question is whether we can view that kind of an interpretation without referring to 7 days.
No, my lords, I was saying in a different context, as far as this starting point is concerned, my contention will still be, it is final. It has to be the stage of the notice. That cannot be tinkered with, my lords.
So that is...
No, that is okay, counsel. But what is pointed out is, suppose we want to change something, can we do it under as a 5-judge or 7-judge?
My lords, with great respect, also depends on what your lordships wants to change. That is why I put up, with great respect, I say that, my lords, if your lordships are further adding to the checks and balances which are there, that is one thing, which may not be contrary to Nabam Rebia at all.
No, but it is, because these two sentences which I read out to you,
my lords, that's why
say that the cloud on the speakers deciding starts the moment you notice under the proviso.
So, my lord, the reason I'm supporting that is by this, that please And that is what Justice Mishra deals with. The moment what follows rule, no resolution, motion, 29 members are all a procedure provided subsequent to the intention to remove a speaker under the constitution. Those are procedural compliances that if you do it in this manner, the speaker will be removed. That is quite different from the problem which Nabam Rebia and Justice Mishra are addressing. That is that till that procedure reaches its culmination, it's after all a continuation of procedure for 179, 181, Rule 11, Rule 18, Rule 20 is a culmination of the procedure. Till that procedure culminates and is put to vote, if a speaker who is all in all under the 10th schedule utilizes that time and alters the pool, and if the only argument is it is inchoate, if the only argument taken is that we do not do it, may or may not happen. Manoj, can that be an answer? Suppose it does happen. Because I'm reversing it. Suppose it does happen. The speaker who between the day the notice is given and it reaches its fructification in the manner the rules and the constitution provides, completely alters the house. And your lordship says the clock starts ticking only when 29 members rise, it's taken up, and that is when the motion is to be considered. Then the damage is done. And why will
हम लोग Sybil, Mr. Paul, Mr. Solicitor, what we'll do is we just take a break for about 5 or 10 minutes. We want to discuss something.
Well, as I
between
just
ourselves
also
on the
wanted to
topic.
play something before your notice, before.
Certainly.
I don't mind, Malaja. I want to play something.
We just want to, yes, we are, of course, we are not concluding the argument. We just
come back.
Because
otherwise we are sitting on the bench and
I see. No, I understand that. I was only saying.
we'll have the pleasure of talking with each other without the mic.
Without the absolutely. Absolutely. Deeply obliged.
We'll just come back in touch.
Yes, ma'am. Yes,
So what we would suggest is that if all of you can conclude today on whether the reference should be made or shouldn't be made, because now we've substantially heard arguments, So just now, Mr. Jetlani, Mr. Mehta, and Mr. Mantra.
Just give me 10 minutes and I'll conclude.
No, we have heard you, Council. We'll let us
Manoj, just-
5 minutes them.
just
I'll
two
also need some
submissions and
time. That's-
Yes.
On why a reference should be.
Yes, Manoj, because there are some things that have been said which I need to clarify, Manoj.
I'll just wrap up, my lords, very quickly.
Because-
My lords, firstly, there is no reason, my lords, for this concern that some one member gives a notice and it indefinitely lies because Rule 11.
Mr. Council already argued all these things.
I'll try to be.
What your point also.
I'll try to be as crisp as possible and finish as quickly as I can. So that is taken care of. B, the Constitution doesn't make any difference between one member making a notice or 20 or 25 making a notice. The conflict of interest starts not merely, my lords, at the stage when 29 members rise to support a motion. Conflict of interest starts the date and intention to initiate a resolution for removal. The words used in 79C proviso is intention to initiate a resolution for removal. The conflict of interest starts on that date. Conflict of interest doesn't cease to happen for 14 days and starts on the 15th day. 7 days, 14 days, 29 MLAs standing is all procedure after that, which is required. So intent of Nabam Rebia was at what stage will the conflict of interest be stopped, and that is what it sought to do there, my lords, in that case. As far as facts of Nabam are concerned, if your lordships want, I'll briefly give. According to me, in the facts of Nabam, disqualification of members specifically arose. It is wrong to suggest that it was an issue only concerning the powers of the governor. If your lordships wants, I can give those 5 facts immediately to your lordships. Those are of some relevance because this was an argument made that never dealt with disqualification of members. I just use my. Well, some 4 or 5 facts. On 19/11/2015, a notice for removal of Speaker of the Assembly was moved by 13 MLAs.
What is the date?
On 19/11/2015, or rather, my lord, I'll start before that, a notice of resolution for removal of the Deputy Speaker was moved by 16 MLAs on 16/11/2015. First, on 19/11/2015, a notice of resolution for removal of Speaker of the Assembly was moved by 13 MLAs. The Chief Whip of the Congress filed a disqualification petition against 14 MLAs of the INC on 7/12/2015, including the Deputy Speaker. The governor issued an order dated 9/12/2015 to prepone the session of the Assembly from 14/1/2016 to 16/12/2015, and it made removal of the Speaker as the first item for consideration. The Council of Ministers was convened on 14/12/2015, and it resolved that the order of the governor was unconstitutional. The disqualification proceedings against 14 MLAs and descendant group were taken up for hearing by the Speaker, and an ex parte disqualification order was passed by the Speaker. Thereafter, the Deputy Speaker conducted the proceedings of the Assembly outside the official Assembly premises and passed an order quashing the Speaker's order for postponement of the session to its original date. And the Governor's order for session to be conducted on such and such date was reinstated. A resolution to remove the Speaker was also adopted by the Assembly on 16/11. So all that I am respectfully submitting, my lords, is the Governor's exercise of power was one part, the Speaker taking up disqualification petitions while his own removal was pending was a specific issue, and thus the court commented on it. It is wrong to say that that was not an issue. As far as my lords had also put a question to me before lunch, as far as a live issue is concerned, my lords, of course, our contention will still remain that on 27th, all that the court said was give them more time. There is no indication of any principle of Nabam Rebia being incorporated, but be that as it may. In any case, on 29th, when the floor test was refused, Nabam Rebia was not in the picture. You refused to take the floor test, which your lordships have time and again said, and if that is so, The nature of petitions that you've now moved and which Mr. Salvik touched upon in the morning,
Already-
all those matters on Article 32. Can you today want this court as the court of first instance to decide all those issues, my lords, in this matter?
You're
So my respectful submission, my lords, is that Nabam Rabia is correct law, requires no tinkering or interference, and does not require a reference, my lords. I'm very, very grateful, my lords, extremely.
Yes, Mr.
I'll take, Lord, only 10 minutes. But I appear for the governor. Lord, on the question of marriage, the lordships are not doing, and I am not supposed to address on the question of marriage. But I'll just point out the flip side of the exercise which the petitioners have, Lord, called upon your lordships to undertake, merely as an academic exercise. And the focal point of the entire defection law, that is the real sovereign, the elector, the voter, Lord, doesn't find place in any of these arguments. Lord, I just wish to, my Lord, bring that fact to your lordship's notice. Lord, we do not have a two-party system. But India is a multi-party democracy. Something will go into the root of this issue when I point out, my Lord, the constitutional dilemma which your lordship would eventually face, my Lord, if this is raised, my Lord, and my Lord sought to be answered purely academically. Lord, we have a multi-party democracy. Multi-party democracy would necessarily mean that now we are in the era of alliances. Lord, constitution always evolves based upon your lordship's experience of how the constitution has worked so far. How is it being used, abused, misused, not used, etc. In a multi-party democracy, there are two types of alliances, Lord, which are contemplated. One is pre-poll alliance and another is post-poll alliance. Post-poll alliance is usually, my Lord, an opportunistic alliance, my Lord, to complete the numbers. But pre-poll alliances are always principled, my Lord, alliances. And that is where, my Lord, 4 paragraphs from Quixote, my Lord, I would read after giving the preface of what I am, Lord, driving at. Lord, in a pre-poll alliance, Lord, taking facts of this particular case, Lord, there was a pre-poll alliance between 2 political parties. Lord, I'll name the parties because all parties, my Lord, are subject matter, my Lord, between BJP and Shiv Sena. As Quixote, my Lord, explains, when you go before the voter, you don't go as an individual candidate. You go as a representative representing a particular ideology. A representative who will go and say that this is our shared belief, this is our shared agenda. Don't vote for the other party for A, B, C, D, E reasons which are negative for the development, for your own upliftment, etc., etc. The voter does not vote for individuals, but it votes for the ideology and the political philosophy which, my Lord, the parties project. Lord, here what has happened, my Lord, we hear the expression horse trading in all defection matter. Here, the leader of the stable, my Lord, took the stable away and started, my Lord, he formed the government with those against whom, my Lord, they contested the election, and a negative vote was given by the electorate against a particular party. Now, my Lord, we come to, my Lord, Quixote Holohan, my Lord, in this background.
No, but Mr. Mehta, how can the governor be heard to say all this?
I am
On the formation of the government between the
I am absolutely
Sena and-
not on the morality part of it.
How can the governor have anything to say on
Lord, your lordships, my Lord, stopped me a little early, my Lord. I was coming to Quixote.
Yes.
Lord, what Quixote does was, Lord, when Quixote, my Lord, was considering the constitutional validity of Schedule 10, there were 2 contentions raised. And why, my Lord, I entered into the facts, not as a
Governor's
political
role,
argument.
when they form government, the
Not on that,
asked them-
Lord, kindly allow me to.
governor asked them to have a trust vote. They
I
got a trust vote.
Lord, let me make it clear. I am not arguing the list between the parties. I am arguing why Nabam, Lord, is a correct law. And my preface on facts is necessary so that I can point out, my Lord, if your lordships would like, my Lord, me to conclude early because of constraint of time, I can conclude, my Lord.
No, but we are only saying that the governor should not enter the political.
I am not entering political arena.
Yes.
I am not entering. Why I am saying this, my Lord? And, my Lord, therefore, my Lord, I made a preface that there is a constitutional argument flowing from, my lord, these facts. And these facts may occur, my lord, in different variety of situations at various, my lord, stages in various states. And your lordship will not confine yourself examination to the facts of this case. Now, my lord, when Quixote Hilohan was examining the constitutional validity, there were two contentions which were raised by the petitioners who were challenging the validity. A, that this negates the freedom of expression of the electors, my lord, that is freedom of expression of the one who is elected member of Legislative Assembly, because I, as an elected person, I means not governor, kindly take it as an academic argument, my lord, as a constitutional argument. I, as an elected person, my lord, represent the views of my electors. So the argument was that unless and until, my lord, I express my views, you are curtailing 19(1)(a) rights. The second argument was right to conscience. Right to conscience. My lord, kindly see, my lord, some of the paragraphs in this context, my lord, if, and my lord, the purpose of my giving, my lord, this background of facts, my lord, which your lordship prima facie found to be, my lord, entering into the marriage, which I never intended to. My lord, please come to, my lord, compilation, judgment compilation, PDF 94. Because here, my lord, the pleadings are that we couldn't go before our electorate. We couldn't go. I'm conscious, my lord, what my role is, and I'm conscious, my lord, what I must point out to your lord.
Yes, yes.
For arriving at a correct conclusion, constitutionally. Page 91, my lord, PDF 94.
Page 94. Yes.
Para 30.
Para 13, my lord. My lord, the argument, my lord, the submission would be that 10th schedule is, my lord, for preventing unprincipled defections and not for the purpose of stifling a genuine dissent. And, my lord, in a multi-party democracy, my lord, your lordship would encounter cases where, in principles, the elected persons will have to go against the leader, my lord, not against the party. And that's what, my lord, the weapon of Article Chapter 10 is not to legitimate dissent. That all right, you want to move this motion, let me remove you. I will decide, my lord, kindly see, this is a very, very serious issue. I am the speaker, I have the power to remove, and I will decide the electoral college who will vote in my no confidence motion. That is what is prevented, not under Article 181, etc. my lord. That is also one of the factors considered. But
Yes.
propriety, Lord, please see 13. These provisions in the 10th schedule give recognition to the role of political parties in the political process. A political party goes before the electorate with a particular program and it sets up candidates at the election on the basis of such program. A person who gets elected as a candidate set up by a political party is so elected on the basis of the program of the political party. The provisions of Para 2(1)(a) proceeds on the premise that political propriety and morality demand that if such a person, after the election, changes his affiliation and leaves the political party which had set him up as candidate at the election, then he should give up his membership of the legislature and go back to the electorate. The same yardstick is applied to a person who is elected as an independent. Kindly come to 97, PDF 97. Lord, one of the contentions, my lord, A, my lord, immediately after, well, I'll read the A. The Constitution 52nd Amendment Act, insofar as it seeks to introduce the 10th schedule, is destructive of the basic structure of the Constitution as it is violative of fundamental principles of parliamentary democracy, a basic feature of Indian constitutionalism, and it's destructive of the freedom of speech, right to dissent and freedom of conscience, as the provisions of the 10th schedule seek to penalize and disqualify elected representatives from the exercise of their rights and freedoms, which are essential to the sustenance of parliamentary democracy. Lord, kindly see 100. Lord, these are my submissions. I am not making, my Lord, submissions on behalf of the governor. These are, my Lord, the issues your Lordship will have to bear in mind while judging the correctness of Nabiya. 30, my Lord. It was strenuously contended by Sri Jethmalani and Sri Sharma that provisions of the 10th schedule constitute a flagrant violation of those fundamental principles and values which are basic to the sustenance of very system of parliamentary democracy. The 10th schedule, it is urged, negates those very foundational assumptions of parliamentary democracy of freedom of speech, of the right to dissent, and the freedom of conscience. That I'll not be able to go before my electorate because I went with a particular ideology and now I'm sitting with an opposite ideology. I'm not, my Lord, on facts of this case. Right to conscience, my Lord, is a right pleaded while challenging the constitutional validity of these provisions, and if your Lordship were to lead power into the Speaker to disqualify people, even in case of a legitimate dissent, exercising the right to conscience, not possibly, your Lordship may have to revisit such challenges if made.
How is
Now,
the governor arguing all this? I do not.
105. My learned friend, I expect him to, my Lord.
Either, Malad, this statement should be recorded as the submissions of the governor.
No,
We'll accept
these are
that.
my submissions.
But he can't be, Malad, have an independent status, Malad, independent of the governor. He's not arguing for the governor and he's saying, I am arguing in my individual capacity. What capacity?
Lord, I'll not, Lord.
No, it's not fair. It's not fair.
Lord,
Because if I start talking about conscience,
say one
Malad,
thing.
then I can
My
say,
learned friend
I
got up
can
at
say,
very
Malad,
opportune time.
party
He should
in
have
power
interrupted.
has a fundamental right to buy off people. Does that party in power have that right?
That's all right.
Let's not
Yes,
let's not make
Can
allegations.
you confine
Mr.
yourself
Mehta,
to...
you
Formulate
conclude it, Mr.
kindly, my Lord.
Formulate
My
it.
learned friend, my Lord, interrupted at a very right moment. He should have interrupted when I raised para 44. Should have.
Para 40.
I'll interrupt
Yes.
you again, don't worry.
But these are all submissions, right?
Yes, my Lord. Lord, now, my Lord, these are the, my Lord, findings.
Para
This is
40.
how, my Lord, the court rejected these submissions. Your Lordships would be, by conferring power on the Speaker to disqualify within that 14 days period, with which, my Lord, I have nothing to say, would be permitting, my Lord, even a legitimate dissent. My Lord, I am not on buying and selling and horse trading. I am on a question where, Lord, again, coming to the facts of the case when
According
out
to you,
of
Mr. Solicitor, what do you suggest with respect to the time frame, time within which this injunction against the speaker should apply?
Lord, it is for them to answer, my Lord, because they have the list between the
But we
parties.
take it that therefore your contention is that it must...
I'll answer.
That the cloud must go back to the date when an intent to remove the speaker is given by the form of a notice.
Right.
My Lord, the counter answer, my Lord, question which I already posed before your Lordship for consideration. My Lord, suppose I were
Is it
to
your
say-
case that the bar on the speaker adjudicating on a petition for disqualification attaches the moment in notice within the meaning of the proviso to Article 179 is
Correct. The reason is this. Look, the reason is this. No, forget the facts of this case. Suppose there is no dissent amongst the party members, but majority of the party members, not maybe 90 out of 100, wants to remove only the speaker. Only the speaker. There is no, my Lord, loss of confidence amongst the leader, namely the chief minister. He has done something extremely wrong and everybody wants that he is not stepping down. Let us remove him by a motion of no confidence. What he needs is one application, my Lord, and he can remove 99%, disqualify 99%, saying that I am the elected speaker. I was elected under a whip issued by your political party, and this is how, ultimately, it may be different thing that the political party may condone that defiance of the whip. But your lordships would be leaving everything at the sweet will and discretion of the speaker, who will be entitled to tailor-make his own voters' list. who will vote in case of his electoral, in his vote of confidence. That's the flip side I wanted to point out.
That's the danger.
No,
That's the danger I'm pointing out, my lord, and kindly appreciate, my lord.
the
Again,
beta. That is what Justice Misra has also observed.
correct,
That
my
was
lord.
the reasoning given by Justice Misra.
That's, my lord, in my respectful submission, my lord, and subject to appealing to your lordships, is a correct reasoning. Lord, kindly appreciate, my lord, here, again, not being political. I am giving an example, my lord, to, my lord, fit into this constitutional scheme. Out of 55 elected persons of a party, 40 people want the speaker to go. There is a lack of confidence. But the speaker says and the chief minister says, which, my lord, prima facie fell from your lordship also, that the chief minister did not face because there was no disqualification, meaning thereby the chief minister would have faced the vote of confidence only after 40 people are in and 15 remains. Lord, that perhaps
We'll formulate your point like this. The speaker should not be permitted to tailor-make the electoral college, which has the power to vote him out of office. That's the point.
That's argument. Lord. Another argument. Lord. Lord, suppose even if I were to say, well, because I don't have the list, that all right, read the provision that the moment a motion is brought to his notice, it has to be moved and, my lord, culminated in either this, Lord, motion losing or motion succeeding within a particular time. Lord, your lordships may do that. My lord, suppose I am suggesting. Kindly, my lord, examine. Suppose the speaker himself doesn't call the meeting and continue to exercise the powers under the 10th schedule. Lord, the majority of the members give a motion of no confidence to the speaker. It is for the speaker to convene the house. He doesn't convene the house. He doesn't bring that motion to the assembly. And in the meanwhile, my lord, he starts at the behest of one gentleman, my lord, proceedings. These are the flip sides. Lord, therefore, the question is, my lord, in facts of this case, Lord, does the question of correctness of Nabam Arabia arise at all? Lord, merely
I just
because
speak what I had said earlier. Your submission is that the speaker should not be permitted to alter the composition of the legislative body, which has the power to vote him out of office.
correct.
That's the long and short of it.
My lord, last submission, and my lord, kindly, this again, my lord, is my worry as an officer of the court, my lord. Lord, whenever you say,
Is being questioned.
whenever my learned friend may enter into politics and governor and how, I am on constitutional principles. My lord, my worry is this. What is democratic principles? If I am elected in the house, I am elected as a leader of legislature party. Correct? My being a leader of the legislature party necessarily inherits my duty to continue to earn their confidence throughout my tenure. If I have my person as a speaker, then my accountability to the elected MLAs goes, my lord, because I will know that the moment somebody says that we have lost confidence in the chief minister, I'll be able to trigger 10th schedule through the speaker, and that remains, my lord, as a sword hanging. Therefore, I say 10th schedule is not a weapon to stifle a bona fide legitimate dissent. It is a weapon to control unprincipled defection. Therefore, if your lordship were to go into the facts of this case, the question is, does that fact, my lord, arise here?
That's a different issue.
It's, my lord, an academic exercise, very intellectual debate and very, my lord, healthy debate. My learned friend also, my lord, raised the level of the debate to a constitutional level. But that would eventually be an academic debate. Suppose your lordship were to say that Nabam is not a good law. I don't wish to argue, my lord, further. But what relief, my lord, would flow thereafter on the main matter? Nabam is a bad law. Suppose your lordships were, my lord, in a combination of 7 were to hold, my lord. Or your lordships can even say that it is per incurium, whatever, my lord, in this combination. Lord, would it affect the final outcome of the proceedings, my lord, after the several events having already taken over? And if that is, the answer is no, would your lordships, my lord, undertake an academic exercise merely because it is raised? Okay. That's the respectful, sir.
You're saying
So, my lord,
Thank you, Mr.
no, kindly note this, my lord, this unbridled power takes away the concept of accountability of the leader of the house. Accountability of continuing to have confidence of his constituents, namely the MLAs.
All right.
And they cannot effectively exercise their freedom of expression and conscience. This is a constitutional argument. Forget whether it's made on behalf of A party or B party. That's not the issue. I have not. It was necessary to give some facts. Therefore, I have given. Your lordship's question was right.
Thank you, Mr. Solicitor.
These are my.
Mr. Jetnani.
Lord, I have filed.
Can we,
I'll have filed my written submission. So they may be treated as.
but can we get some little time tomorrow, man? An hour or so for both of us as well.
Hour.
40.
We'll hear Mr. Jetlani and Mr. Maninder Singh all three of you tomorrow. Between all three of you, can we give you half an hour between the three of you so that then Mr. Sibal and
I
Mr.
was tempted to make this request, but I couldn't muster up the courage. He mustered. But the role is over.
But because it was 4 o'clock, that's why I mustered it up. Not that I have courage,
Mr. Council, you have asked for the 1 hour, we will grant you 45 minutes. If you don't ask for 45 minutes, you have given 30 minutes.
What we'll do is we'll start soon after the mentioning is over tomorrow.
Very well.
And
I'm so grateful.
we'll give between all three of you, we'll give you half an hour tomorrow, so that then Mr.
I'll
Sibal
we'll respond and we make it short. Very pointed. We're very pointed. We're not going to waste your lordship.
Right.
Your lordship may take it from us.
All right.
This meeting is being recorded. is being recorded.
ठीक है, वो अपने जरूरी है। Good morning, ladies and gentlemen. We are about to begin the function. I request you all to take your seats. And also a small, gentle reminder to keep your phones on the silent mode, please. Namaskar, ladies and gentlemen. On behalf of the Chief Justice of India and the judges of the Supreme Court, a very warm welcome to you all on this special occasion as we celebrate the 73rd anniversary of the establishment of the Supreme Court of India. On this occasion, we are honored by the august presence of the Chief Justice of the Supreme Court of Singapore, Honorable Mr. Justice Sundaresh Menon. We would like to welcome on the dais Honorable Dr. Justice Dhananjay Yashwant Chandrachud, Chief Justice of India, Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India, Honorable Mr. Justice K.M. Joseph, Judge Supreme Court of India, and Honorable Mr. Justice Ajay Rastogi, Justice Supreme Court of India. May I request Honorable Mr. Justice Sanjay Kishan Kaul to give the welcome address.
Chief Justice of India, Dr. D.Y. Chandrachud, Chief Justice Singapore, Shri Sundaresh Menon, my brother Justice Joseph and brother Rastogi, judges of the Supreme Court, retired Chief Justices and judges of this court, Shri R. Venkatraman, Attorney General, judges of the Delhi High Court, Shri Tushar Mehta, Solicitor General, former judges, Shri Mishra, Chairman, Bar Council of India, Shri Vikas Singh, President of Supreme Court Bar Association and President of the SCORA, members of the legal fraternity, ladies and gentlemen. As we celebrate the 73rd year of our establishment of the Supreme Court of India, it gives me great pleasure to welcome you all to the first edition of this annual lecture series. On behalf of our attendees and the Supreme Court, I would like to thank the Honorable Justice Sundaresh Menon, Chief Justice of the Supreme Court of Singapore, for agreeing to deliver the lecture. Under his leadership, the Supreme Court of Singapore has reaffirmed its position as an exemplar for judicial institutions across the world. It has stood as a monument to judicial integrity, impartiality, and independence, and it has played a critical role in the development of Singapore as the commercially sophisticated state that we recognize today. Chief Justice Menon is universally recognized as a brilliant and hands-on administrator. Singapore is now a renowned international commercial court, which was his brainchild. He leads the process of expanding Singapore's Legal Services Commission. He also has an eye towards the development of younger members of the bar, as he heads the Academy of Law, which works towards enhancing legal capabilities among the lawyers. He has previously occupied some of the most exalted positions and responsibilities in his legal career. He is the youngest Chief Justice in his country's history. He has previously served as the Attorney General, as the Deputy Chairman of the Singapore International Arbitration Centre, and as the Managing Partner of a leading global law firm. We are honored to have him here today, and we look forward to hearing and learning from his insights. The Indian legal system as we know it today has a long and contested history. However, the origins of the Supreme Court of India as the apex judicial institution in the country are easier to trace. The journey commenced in 1950 when the Supreme Court assumed its duties from the Federal Court of India, which at times was supervised by the Privy Council. At this point, the court conducted its sitting in Parliament House until it moved to its presence more iconic venue in 1958. From a bird's eye view, the building designs projects the scales of justice, perhaps revealing how even the most prosaic of matters must necessarily be located within its virtue. Since this period, Supreme Court has naturally found itself in the midst of India's intensely political atmosphere. After independence, the country was bourgeoning with different aspirations, particularly with respect to the areas of economic development and social reforms. The Indian Constitution granted Supreme Court a regnant and critical position in this process, to act as the apex arbiter of disputes, being limited only by boundaries it set upon itself and the confines of the Constitution itself. The present lecture series was conceived with the idea of to provide a degree of reflexivity in his endeavor. really an endeavor of our Chief Justice. The Supreme Court, as it must, faces an intense amount of scrutiny every day. It is rightly believed to be custodian of fundamental rights and the defender of individual freedoms. However, in this humdrum, perhaps it has become difficult to dispassionately evaluate the positions taken up by the court, particularly through social, historical, and comparative lens. Over the last 73 years, there have been many achievements and many challenges. At this present juncture, it was rightly felt that this would be an opportune time to take a stock of where we have reached and to chart a course for the future. We fervently hope that through this lecture series, with the aid of distinguished speakers such as Chief Justice Menon, we can contribute to this process of strengthening the institution that we so revere. Chief Justice Menon today will speak about the role of judiciary in a changing world. As a prelude to his speech, I would like to take this opportunity to elaborate on my aspirations for this lecture series and what we can expect from it as it develops further in the future. As I hinted earlier, the Supreme Court has always been influenced by the dynamics of contemporary political forces, the dominant economic realities, and the landmark social events. As Henry Sheen said, every age has its problems, by solving which humanity is helped forward. The court thus has to reorient itself sometimes radically in the face of different challenges. Immediately after independence, the court's concern was to play a supporting role in the institution building process, cautiously developing its own sphere of influence. Later, during the period of economic instability, the court took a more active role in questions relating to the economic order, such as through the decision in the bank nationalization case. Post the emergency came a period where Supreme Court took upon the task of administrative review in a more serious way and started developing rigorous due process jurisprudence through a case including Maneka Gandhi. Then came the advent of public interest litigation, which has become synonymous with the right-based litigation in India today. We are thus left to contemplate what our present generation great challenge could be. To contrast the contemporary modern world from its predecessor, one can certainly point towards forces such as globalization and multiculturalism that are rapidly reconstituting the world as we know it. Judicial institution must, like every other social entity, cannot claim to be immune from this process or remain as mute spectators. Domestic laws are increasingly affected by happenings in other parts of the world, and vice versa. Progressive judicial decisions in other countries can have a reasoning effect in other jurisdictions, forcing an examination of one's own rules and methods. On the flip side, there are issues of transnational importance that can simultaneously invoke the attention of multiple jurisdictions, such as cyber security, global warming, and terrorism. Thus, since the nature of challenge is global, our response cannot afford to be local. Justice Oliver Wendell Holmes famously remarked that life of the law has not been logic, it has been experience. I thus ask, what better source of experience can there be than the lives of others? As the world has gotten closer, there is a greater overlap in our social challenges. Questions of balancing economic development vis-a-vis preserving labor rights, interpreting our laws in a ways that can protect our most marginalized communities, enabling the state's desire for collective security while preventing individual freedoms from being trampled upon. These are a common set of questions that every society across the world must answer. We do not have to follow the dominant mode of thought, but we can only develop our unique positions once we know what has been tried, what has succeeded, and what has failed. Although we are bound exclusively by our own laws, us judges increasingly cite foreign judgments, not as precedent, but as reflections of how other people around the world have interpreted these common social questions. In Justice K. Puttaswamy's case, we looked at the experience of countries such as US, UK, South Africa, and Israel, and the realms of privacy and data protection laws, as India did not have such a comprehensive regime. Similarly, in the interregnum, as our country develops its own cross-border insolvency law framework, India tribunals have been adopting the best practices from countries such as Singapore and Canada. In this context, I hope this lecture series will initiate a more systematic and a more rigorous process of developing our own jurisprudence through a comparative legal method. Ultimately, the Indian Supreme Court is part of a larger global fabric, that is, the order underpinned by the rule of law. Rule of law stands as the antinomy of capriciousness, despotism, arbitrariness, and tyranny, and can thus be considered as truly international and intrinsic human value. As defenders of this idea, courts across the world converse in a shared language of liberty, democracy, and equality. As we continue working towards strengthening these relationships, I would like to leave you all with a quote from Dr. Babasaheb Ambedkar. The Constitution is not a mere lawyer's document. It is a vehicle of life, and it is always the spirit of age. Thank you, and Jai Hind.
Thank you, sir. May I now request Dr. Justice Dhananjay Yashwant Chandrachud, Honorable Chief Justice of India, to address the audience.
Honorable Justice Sundaresh Menon, Chief Justice of the Supreme Court of Singapore, my distinguished colleagues in the Supreme Court of India, distinguished former Chief Justices of India, former judges of the Supreme Court, we are deeply beholden to you for your presence this morning. Judges of the Delhi High Court, the Learned Attorney General for India, Mr. R. Venkatramani, Learned Solicitor General Mr. Tushar Mehta, Mr. Vikas Singh, President of the SCBA, Mr. Manoj Mishra, President of the SCORA, Mr. Manan Kumar Mishraji, Chairperson of the Bar Council of India, distinguished guests, members of the bar, ladies and gentlemen. I join my colleague Justice Sanjay Kishan Kaul and all other colleagues in welcoming Chief Justice Sundaresh Menon. I know that all of you are eagerly awaiting to hear Chief Justice Sundaresh Menon's lecture, and so am I. We have gathered today to commemorate the 73rd anniversary of the establishment of the Supreme Court of India. The Supreme Court came into being on 28 January 1950, 2 days after India adopted its constitution and became an independent sovereign republic. From this year, we will be commemorating the first sitting of the Supreme Court each year by organizing the Supreme Court of India annual lecture. It is an honor to have Chief Justice Menon deliver the first annual lecture on the theme, the role of the judiciary in a changing world. We have, as our distinguished guest today, a jurist extraordinary. He has the unique distinction of having served as both the Attorney General and now as the Chief Justice of Singapore. He is truly in the tradition of scholar judges. Just yesterday, he presented to me one of the first few copies of his book titled Transnational Commercial Disputes in an Age of Anti-Globalism and Pandemic, which he has co-authored with a distinguished scholar, Anselmo Reyes. So we couldn't have had a better speaker, judge, and scholar than to begin this lecture series this morning. The Federal Court, created under the Government of India Act 1935, was the predecessor to the Supreme Court. But its jurisdiction was limited to adjudicating disputes between provinces and federal states and hearing appeals against the High Court decisions. In contrast, the Supreme Court's jurisdiction not only extends to hearing criminal and civil appeals, but also extends to the enforcement of fundamental rights and disputes involving the states of the Indian Federation. In addition, our court can advise the President on important questions of law. The Constitution has envisaged a unified and integrated judiciary with the Supreme Court of India at its apex. the Supreme Court serves the world's most populous democracy and is in true aspects a people's court because it's a collective heritage of the people of India. The Supreme Court's opening session was held on 28 January 1950 in the Chamber of Princes in the Parliament building, where the Federal Court sat for several years. The inaugural proceedings were marked by an air of solemnity and simplicity. At its inception, the court had a sanctioned strength of 8 judges, but the court started functioning with an occupied strength of 6 judges. During the inaugural session, all 6 judges of the Supreme Court, including Chief Justice Harilal Kania, took their seats on the dais. In attendance were the Chief Justices of the High Courts, the Prime Minister, other ministers, ambassadors, and diplomatic representatives of foreign states, a large number of senior and other advocates of the court, and other distinguished visitors graced the occasion. In his address, Chief Justice Kania prophesied that the court will play a great part in the building up of the nation. Chief Justice Kania's words were prescient. He said, and I quote him, "India has chosen to have a written constitution, and the duty of interpreting that constitution with an enlightened liberality falls on the Supreme Court. The Supreme Court will declare and interpret the law of the land, and with the high traditions behind the judiciary of this country, we are convinced that the work will be done in no spirit of formal or barren legalism. It will be our endeavor to interpret the Constitution not as a rigid body, but as a living organization, having within itself the force and power of self-government." Those were the words which have animated successive generations of judges, including so many distinguished amongst them who are present with us today. In its first year itself, the Supreme Court heard a number of cases related to matters of fundamental rights, including the freedom of speech and equality. As the court began its functioning, several doyens of Indian constitutional law and many members of the Constituent Assembly appeared before the court. The chairperson of the drafting committee of the Constitution, Dr. B.R. Ambedkar, also appeared before the Supreme Court in 1952 in the celebrated State of Bihar versus Sri Kameshwar Singh. Ever since the Constitution was enacted, the Supreme Court has sat in Delhi. A lesser known fact is that the Supreme Court has functioned outside Delhi on 2 occasions, that is in Hyderabad in 1950 and in Kashmir in 1954. On the coming into force of the Constitution, all appeals of Privy Councils in Hyderabad and Kashmir were transferred to the Supreme Court. The appeal records of these courts were in local languages, and their translations would have entailed much expense and time. A far cry from AI-assisted machine translations today. Therefore, the Chief Justice decided to constitute a bench in Hyderabad and Kashmir to hear and decide the pending appeals. In 1954, a decision was taken to construct a separate building for the Supreme Court. The chief architect, Ganesh Bikaji Devdalikar, designed the building in the shape of a balance with a pair of scales of justice. When you enter the court premises, you will find the pensive statue of Mahatma Gandhi facing the court building. The court's logo consists of the wheel of Dharma with the inscription Yato Dharmastato Jayaha, meaning where there is Dharma, there is victory. These are not merely ornamental imageries. They represent the values of the Constitution and the aspirations of our people. They serve as a reminder for both judges as well as lawyers to act righteously. The present Supreme Court complex was inaugurated by Dr. Rajendra Prasad on 4 August 1958. At the inauguration, Chief Justice S.R. Das presciently laid forth the responsibility of the court when he said, "To us, the new building stands forth as a solemn and sublime symbol of the majesty of the law. The portals of this palace of justice shall be open to every person who may seek redress for wrong, if any, done to them, by their fellow citizens or by the state, and justice will be denied to none. The lowliest of the low, be he a citizen or a non-citizen, may as of right claim here equality before the law, and shall receive from this temple of justice equal protection of the laws. Later on, in July 2019, the additional building complex of the Supreme Court, where we are today celebrating this event, was inaugurated. The court's workload during the initial years was a fraction of what we witness today. In the annual report of 2005-2006, one of our former distinguished judges who is present here, Justice B.P. Singh, recounts that when he visited the Supreme Court for the first time in 1956, the proceedings were solemn and virtually dull. He also observed that at a time only 5 to 6 lawyers would be present in the court hall. Over the years, the workload of the Supreme Court has increased. Every day now, the Supreme Court has hundreds of cases on its docket. The judges of the Supreme Court and the staff of the registry put up tremendous work to ensure the speedy disposal of cases. Just to give you a simple sampling, in the last 3 months, 12,108 cases were filed before the Supreme Court. 12,471 cases have been disposed of. We have to also remember that the functioning of the Supreme Court was very different from the provincial high courts as they then existed. Many judges who are serving in the provincial high courts found it difficult to get accustomed to the new ways. When Justice Muhammad Hidayatullah was elevated to the Supreme Court in 1958, Mondays were miscellaneous days. Justice Hidayatullah's first day in court was a Monday. Late Sunday night, he found a huge bundle of 35 special leave petitions by his bedside. He was expected to have read them by the morning. However, Justice Vivian Bose, with whom Justice Hidayatullah was staying at the time, advised him to read only the later cases, because most of his colleagues would have only read the earlier cases, and that way he could control the conversation in the courtroom. Like Justice Hidayatullah, we, the bar and the bench, are also learning and adapting to the new norms on a daily basis. Over the years, the sanction strength of the court was increased, and currently it stands at 34 judges. As the number of cases increased, the court started sitting in smaller benches of 2, 3, and 5 judges. The Supreme Court's jurisprudential approach has been evolving. In the 1970s, the court adopted a broad, purposive, and contextual interpretation of the Constitution. In the past few years, the court has furthered the transformative vision of the Constitution by recognizing and protecting fundamental rights such as the right to privacy, decisional autonomy, and sexual and reproductive choices. Our court has emerged as a strong proponent of gender equality, whether it be in its interpretation of the laws of inheritance or securing the entry of women in the armed forces. The court has also ensured that the criminal justice administration is not delinked from the framework of human rights. For instance, while the death penalty has been upheld to be legal and constitutional, the Supreme Court laid down various mitigating and aggravating circumstances that a judge should take into account before awarding the sentence of death. This ensures fairness in the process. Procedural innovations, open court hearings in reviews arising out of death penalty cases, or psychiatric assessment of death row convicts have a humanizing influence on the law. Thus, the court has sought to use the language of the Constitution to humanize law and act as a protector and defender of fundamental rights and liberties. In the past few decades, India's legal landscape has undergone significant changes with the adoption of legislation such as the competition law and the insolvency and bankruptcy code. Consequently, commercial matters now comprise a significant part of the daily docket along with criminal matters. While dealing with such cases, the court has often drawn upon the new and emerging jurisprudence developed in other jurisdictions. To give you just one example, in dealing with the insolvency and bankruptcy matters, the court has often referred to principles enunciated by the Singapore courts because of a similarity in legislation. I did so in my decision in EBIC Singapore Private Limited versus Educom Solutions. In arbitration cases, the court has taken a conscious stand of upholding the sanctity of contracts. The Supreme Court has made a constant endeavor to ensure access to justice for everyone. The court has facilitated increased access to justice by diluting the requirement of locus standi through public interest litigation in the 1980s, by which anyone can approach the constitutional courts in India to seek a redressal of a violation of their fundamental rights. By doing so, the court, because of their social and economic disadvantage, this has provided a space for citizens to converse with the state on equal terms. In turn, the court has been using its jurisdiction to make the rule of law a daily reality for persons belonging to the marginalized communities. During the COVID-19 pandemic, the Supreme Court adopted innovative technological solutions to reach out to the people by adopting video conferencing of court proceedings. During the period between 23rd March 2020 and 31st October 2022, the Supreme Court alone heard 3.37 lakh cases through video conferencing. We updated our video conferencing infrastructure in courtrooms at a meta scale, and we are continuing to use such technological infrastructure to allow a hybrid mode of court hearings that allows parties to join court proceedings from any part of the world online. In the recent budget, the Government of India has announced a provision of rupees 7,000 crores for phase 3 of the e-courts project. This will help to enhance the accessibility of judicial institutions and improve the efficiency of the justice delivery system in India. Such endeavors will ensure that the court truly reaches out to every citizen of our country. If we peruse the history of this court, we realize that the history of the Supreme Court is a history of the daily life struggles of the Indian people. The mentioning list every morning in the court of the Chief Justice of India spans anywhere between 60 to 100 cases. Through these seemingly innocuous requests, we can sense the pulse of the nation. Above all, we send a message in this uniquely citizen-centric initiative, and that message is of an assurance that this court exists to protect our citizens from injustice. Their liberties are as precious to us as to them, and that the judges work in close connect with our communities. In conclusion then, let me say that there should be 3 principles which should guide our approach, and I borrow something from what has been delivered by the greats of the past who have decided cases before us. First is that we must apply the precautionary principle in the work which we do. Second, we as judges must apply the principle of sustainable development, because it is the principle of sustainable development which will ensure that the institutions which have been created to us will be safe and sound when we as pilgrims in this path hand over the baton to our successors. And third, we must always remember the public trust doctrine, because we hold this institution in trust for the future. So if we apply these 3 principles, the precautionary principle, the principle of sustainable development, and the public trust doctrine, not just in the context of environmental litigation, but each day of our lives, we will ensure that our court remains vibrant despite climate change. For the court, there are no big or small cases. Every matter is important, because it is in the seemingly small and routine matters involving the grievances of citizens that issues of constitutional and jurisprudential importance emerge. In attending to such grievances, the court performs a plain constitutional duty, a plain constitutional obligation, and a plain constitutional function. Before I conclude, I thank Chief Justice Sundaresh Menon from the bottom of my heart for unveiling this lecture series. As I said, we couldn't have had a more distinguished jurist across the world than him to deliver this inaugural lecture. Thank you, Namaskar.
Thank you, Your Lordship. On this special occasion, may I request the Honorable Chief Justice of India, Dr. Justice D.Y. Chandrachud, to present a memento to the Chief Justice of the Supreme Court of Singapore, Honorable Mr. Justice Sundaresh Menon. Ladies and gentlemen, the Supreme Court of India is proud to announce an annual lecture series on the various facets of the role of the judiciary. May I now request the Honorable Mr. Justice Sundaresh Menon, Chief Justice, Supreme Court of Singapore, to present the inaugural lecture on this lecture series entitled The Role of the Judiciary in a Changing World.
The Honourable Justice, Dr. Justice D.Y. Chandrachud, Chief Justice of India, the Honourable Justices of the Supreme Court of India, the Honourable former Chief Justices and former Justices of the Supreme Court of India, the Honourable Shri Venkataramani, the Attorney General of India, distinguished guests, ladies and gentlemen. It is truly a great honour for me to be invited to address you as part of the first Supreme Court of India Day celebrations, commemorating the inauguration of this august institution on 28th January 1950. I thank the Honourable the Chief Justice for the invitation. I thank my friend Justice Kaul for his very generous introduction, and I thank the Supreme Court for the generous hospitality that has been extended to me and to my colleagues in connection with this visit, an especially delightful one coming as it does following 3 years of considerable disruption for all of us. The Supreme Court of India is among the busiest courts in the world, and its justices among the hardest working judges because of the immense caseload that they carry. I saw this myself when I was honored to observe proceedings yesterday in the Chief Justice's court alongside him. It is therefore a tremendous privilege for me to have spent several hours with the Chief Justice and a number of his colleagues, and I very deeply appreciate all that they have done to welcome me to India. Over the course of the last 73 years, when the Supreme Court has rendered justice according to the usages, the laws, and the Constitution of India, the world has changed immensely. But in many ways, the fundamental setup of our courts, whether here in India, in Singapore, or for that matter in most other places around the world, has largely remained the same. We are charged with the same constitutional responsibility to do justice, and we take a broadly similar oath of office to resolve controversies of all sorts according to law, without fear or favor, affection, or ill will. The rule of law, which is a fundamental pillar of our systems of government, depends on this. Yet it is an inescapable reality that changes are taking place in the world around us that are dramatic both in rate and in scope. This raises the question of how we should square our unchanging, unyielding judicial responsibility with the relentlessly dynamic world that we find ourselves in today. How should we envision the role of the judiciary in this changing world? That is the subject that Chief Justice Chandrachud has invited me to address, and this opens an extremely timely conversation, if I may say so. Today, I will propose a vision for a future-ready judiciary in 4 parts. First, I will briefly reiterate what is demanded of us in our judicial role. This will set the context for the subsequent discussion. I will then describe what I refer to as the perfect long storm facing judiciaries around the world. In the third part of my remarks, I will explain why we, judges, must respond urgently to this series of challenges precisely because of the effects of these changes on our ability to discharge our responsibility as judges. And finally, I will sketch out some ways in which the functioning of the judiciary could evolve to meet these challenges. Even though judiciaries may not be equipped or mandated to address some of the issues that the world is facing, my suggestion will be that we nonetheless can and must refine and modernize our vision and understanding of the judicial role if we are to remain able to administer justice effectively and to help maintain order and legitimacy in our societies. So let me begin by reiterating some basic notions of the judicial role. In Marbury and Madison, Chief Justice John Marshall famously declared that it was emphatically the province and duty of the judicial department to say what the law is. To those of us raised in a constitutional framework based on the separation of powers, this is foundational. Parliament makes the law and the executive branch carries it out. But the imperfections of human foresight, the limitations of language, the constraints of the Constitution, and the human tendency to try to get what one wants all come together to give rise to disputes over what the law is, and therefore over whether one is acting lawfully. And when this happens, it is the courts that must decide. This, at its core, is our role, to resolve the many disputes that are part and parcel of societal life. Indeed, as Chief Justice Chandrachud recently observed, it is in the seemingly small and routine matters involving grievances of citizens that issues of moment, both in jurisprudential and consequential terms, emerge. When the judiciary functions well, it serves as a stabilizing force in society by easing tensions and giving final and authoritative directions to help all of us get through these numerous daily conflicts. When it functions well, the judiciary serves as part of the glue that holds the various moving parts together. To discharge this role, there are perhaps two core requirements. First, those appointed must have the competence and the capacity to discharge the responsibility that is cast upon them. And second, their status as the arbiters and umpires of society has to be accepted by the subjects of their decisions. As Alexander Hamilton famously noted, we hold neither the sword nor the purse, only judgment. Consequently, a judiciary needs legitimacy to function well, and this is secured when it enjoys the confidence of the public. Gaining that confidence is a function of many factors. Does the public generally believe that we are acting honestly and wisely, impartially, independently, and with integrity? Does it believe that we are competent to discharge our duties? Are we regarded as being out of touch and existing only to serve the needs of the wealthy and the powerful? Or does the public believe that we are here to serve justice and that we are resolute in our commitment to bring down whatever obstacles stand in the way? I ask you to keep these two requirements, competence and legitimacy, in mind as we turn to examine the challenges that judiciaries around the world now face. I speak to you in the aftermath of what might be described, perhaps with some optimism, as the aftermath of the COVID-19 pandemic. But it is striking that when future historians look back at this time, the pandemic might only be one amongst a number of world-changing events that have taken place over the past few years. This has been a time when we have witnessed dramatic shifts in the global political environment, with the outbreak of what might prove to be a long-drawn war in Europe. Lurking in the background are even graver threats, such as the prediction by the Intergovernmental Panel on Climate Change that we are at the precipice when it comes to climate change. Singapore's Senior Minister Tharman Shanmugaratnam recently suggested that the world faces a perfect long storm of global challenges. Alongside global geopolitical instability, global health security, and the climate change crisis, we see the threat of stagflation and the risk of growing economic and social inequality. He called this a perfect long storm because he considers these to be a confluence not of random shocks, but of structural issues and insecurities that will be with us in the long term. These global challenges concern us as judges because they will have an impact on one or both of those essential elements of our work, competence and legitimacy. They place greater demands on the level of competence and the kinds of competencies that judges will need in order to be able to do their work. And they add significantly to the pressures threatening to undermine the legitimacy of public institutions, including courts. I have identified 6 specific types of challenges, most of them arising directly or indirectly from these global challenges, which have particular relevance to courts and legal systems. They come together to form what we might think of as a perfect long storm bearing down specifically on justice systems around the world. The first 3 sets of challenges have a direct impact on the ability of judges to competently discharge their duty of adjudicating disputes. They revolve around the growing complexity of the disputes that will come before us. Let me elaborate upon them in turn. First, the global challenges that I described earlier on will give rise to new legal issues. Though these challenges might first and foremost be political problems, almost all of these problems will also have a legal dimension, which means that the responses to these challenges, whether in the form of executive action, legislation, or private initiatives, will sooner or later give rise to disputes that will end up before the courts. The climate crisis provides an obvious illustration of this, with environmental regulation, green financing, and corporate governance being just some examples of a wide gamut of potential legal issues in this area. And even inaction in the face of these global challenges is likely to give rise to litigation. In the area of climate change, there are prominent examples of private individuals and entities bringing governments to court for omitting to do enough to curb carbon emissions, with notable judgments having been issued in favor of such claimants by the highest courts in the Netherlands and Germany. If these global challenges are here to stay for the foreseeable future, then all judiciaries will have to be ready to deal with their fact patterns and legal implications. We can expect such disputes to be complex, demanding, and time-consuming. And to be equipped to cope with them, courts will have to be prepared to develop new legal concepts and tools, as well as new ways of deploying existing legal principles and practices. The second type of challenge is what I call the complexification of disputes. This refers to complexity that arises not from a specific subject matter or factual pattern, but rather to the growing complexity of disputes generally, stemming primarily from the rapid rate of advance in science and technology. There are 2 facets to this trend: growing technical complexity and growing evidential complexity. Technical complexity comes from the increasing amount of scientific and technological knowledge that adjudicators will need to grapple with. The world around us is being transformed by technology. Contracts are entered into using algorithms, and vehicles are learning to drive themselves, which means that familiar legal concepts premised on the actions of human agents can now give rise to uniquely complex legal issues. Advances in science can similarly transform ordinary questions, such as a person's state of mind, into potentially complex inquiries into fields such as psychiatry. So too has the evidential complexity of disputes exploded, because our reliance on electronic communications and systems and the massive amounts of data that they collect means that even a modest transaction can easily generate volumes of documentary evidence. The complexification of disputes gives rise to the very real possibility of cases that are so complex or voluminous that they strain the ability of any single human adjudicator to process. In one construction arbitration, for instance, the tribunal reportedly received written submissions extending to 10,000 pages. Applying an estimate of 6 minutes to read and digest each page, it would take an arbitrator 1,000 hours, or about 6 working months, to read the submissions, to say nothing of the time it would take her to evaluate them in the light of the rest of the material. But even more routine cases may prove significantly more demanding to try using conventional methods, thus increasing the cost of litigation and compromising the expeditious disposal of cases. That is aside from the personal toll that working on such cases takes on lawyers and adjudicators. As science and technology continue their inexorable advance, these challenges will only grow. We cannot rely solely on traditional case management tools to deal with the problem of complexification. Instead, judiciaries will have to consider new and potentially radical ways to contain and downsize disputes or face a real crisis of capacity. And a third set of challenges come from the fact that legal issues increasingly disregard jurisdictional boundaries. This is because we are becoming more economically interconnected than ever before. Despite the well-publicized phenomenon of countries around the world shutting their borders and turning inwards at the start of the pandemic in early 2020, by the end of that year, transnational trade had recovered to pre-pandemic levels and has continued to grow since then. The volume of international commercial disputes that have connections with multiple jurisdictions will therefore keep rising. But international commercial dispute resolution is by its nature decentralized. There is no single predetermined control center for each dispute. Instead, each court has the prerogative to rule on jurisdictional disputes in the proceedings brought before it, including questions of whether the dispute is better brought before another court or arbitral tribunal, or has already been decided in another forum. In addition, we are sure to encounter new legal issues in areas ranging from cryptocurrency to environmental, social, and governance regulation and litigation, all of which rarely heed jurisdictional boundaries. The case for convergence or harmonization in many of these areas is obvious. If different jurisdictions applied their own idiosyncratic standards in deciding challenges